Item
3 also.
3.
Yes.
What do you want?
This matter will be listed after vacation.
After vacation, why?
I have taken consent from other parties.
Okay. If you have taken consent from other, it has to be listed after vacation.
Yes, also.
Mr.
Sita Jo.
Land Council for the appellant. Your name is there.
No, also. I'm appearing on behalf of Deep Pangi.
Hearing on behalf of Mr. P. Pangan, Land Council for the appellant. With the consent of the Land Council of the other side. Praise for listing this matter after 3 weeks. The prayer is allowed. List this matter after 3 weeks.
Much obliged.
After vacation,
Yes, also.
at least 4 weeks. Okay.
Much obliged.
Lordship, I would like to mention item number 19, Your Lordship. Here I have to file affidavit, Your Lordship. May kindly give 3 weeks time to file affidavit.
3 weeks time for what?
Filing affidavit, Your Lordship.
This is order. Well, keep the order for the time being. Let the matter be called for. Are you busy or going somewhere?
No,
Wait for some time then. In orders, we'll see the office note and then pass order accordingly, okay?
Ah.
Whosoever wanted adjournment will grant, but then let us wait for some time.
all right.
May I please, Your Lordship,
Yes.
item number 24, Your Lordship. It's a hearing matter, Your Lordship.
Item
So-
24,
Yes, Your Lordship. I have
criminal
taken-
appeal.
Yes, Your Lordship. I have informed the other Lordship. May I please that this matter may be listed after vacation, Your Lordship.
After vacation.
Lordship.
Mr. A.K. Singh, Land Council for the appellant. Praise for listing this matter after the ensuing Puja vacation, to which Ms. L. Hadi, Land additional BP has no objection. Prayer allowed. List this matter after the ensuing vacation. Okay.
Okay.
Matter 6 after vacation. Since matter is represented by what is the employer, I requested. Adjournment matter. The second consent from party. Okay. Same, similar, huh? Mr. Tapa. David Tapa. Oh,
Your Lordship, I want to mention item number 5. Here, Your Lordship, the leading counsel N. Tajay is out of station due to illness of his daughter.
it's a criminal petition.
Yes, Your
You want adjournment.
Yes, Your Lordship.
Your name is not there.
No, Your Lord.
Mr.
El Tatam.
Land Council. El Takam.
Tatam, that is Takam.
Tatam.
Tatam.
Tam is that the conducting counsel, Mr. N. Tajay, is not well today. Therefore, pray for adjournment of the matter. To
After 3 weeks, Your Lordship. After 3 weeks.
which- to which Ms. El Hadi, planning additional business has no objection. Prayer allowed. List this matter after 3 weeks.
Much obliged.
What is this matter about?
Saving the notice issued by
What is this? Civil revision. When do we want this matter to be listed?
notice, the Arunachal Pradesh, the notice is from the Arunachal Customary FX Court. So they have issued alleging that my minor son has assault, committed sexual assault with his wife, the one who is the complainant. So they are holding the meeting, proceeding day after tomorrow.
Any FIR filed?
I have filed after receiving, because I was Johnson, after receiving the notice, I filed from before the civil case for investigation, for recommendation of investigation and here.
You are filing what?
I am filing for passing and setting aside of the notice.
528. 528 of CRPC.
No.
What? Civil.
Under 227.
227. So your son has been issued notice by the GB,
by
Kaba.
Kaba, having because they have that the forum is Arunachal Customary FX code from situated in Itanagar. However, I am from Alo and on the jurisdiction issue only.
When?
Today I have filed already because they are holding the proceeding day after tomorrow.
Let us see. Okay. It's the last item.
Item number 1.
Yes.
Yes,
Yes.
this is my lord, anticipatory matter in connection with 2 FIR, my lord, arising out of same incident, my lord.
2 FIR.
2 FIR, my lord. Incident is same, by. From one incident, there is 2 FIR, my lord. FIR number, my lord, is one is my lord, rowing PS case number 14 under 14, my lord, 2025 under section 61 to 117 subclause 4119 subclause 2 BNS 2025 also read with
What is 61 2?
6. This is my lord, pertaining to my lord,
My lord, this is criminal conspiracy.
insurance company.
Criminal conspiracy. In order to
120B.
Yes, my lord.
Yes,
In order
What
to
is this one? 117.4?
174 is causing grievous hurt by group of people, more than 5. More than 5 people, my lord.
No, that 174. Corresponding IPS.
My lord, 174 is causing grievous hurt by group of people, more than 5 people.
No, if it involves more than 49 or what?
4 BNS, my lord.
4, my lord.
Is corresponding IPC?
Corresponding IPC, that I'm not sure, my lord.
How can it?
My lord.
Earlier opinion, my lord,
Just a minute.
I believe, my lord, my lord,
117. $325. What is 191? See, this BNSs are new.
yes, my lord.
Always please come prepared.
My lord.
We need to know,
Yeah.
including you, me, everyone need to know, even the advocate sitting behind also. Only spelling out the section will not help at the moment.
My
We
lord.
need to know.
My lord. My lord.
Repeatedly, if we know, repeatedly it will count, if you read, then we will be able to know later on. Okay,
Right.
but since it is a new, always come prepared with. Rioting, see, 191 is rioting. Punishment for rioting. And PDP, no problem.
120, 190 is my unlawful assembly.
Hmm?
190 is my lord, unlawful assembly.
Where is 190? 190 is not there.
190, 191, both are there, my lord.
90 is also there. No,
Yes, yes, my lord.
190, my lord, is in FIR,
not seen
second FIR, my lord.
it's not in the second FIR.
FIR.
Okay, just let us just see. FIR. Oh, this is rowing case.
Yeah, my lord.
Yes, my lord.
That's why I was supposed to, earlier, already deal with this case, my lord.
Because there was a two different occasion, different
Yes,
situation, different location also.
Right.
And a place of occurrence also different.
No, my lord,
It may be a continuous.
continue, it is 2-3 part, my lord.
Hmm.
Start from
Right, right.
Mecca, my lord. Thereafter,
One's at a hospital, one's in a police station, and an outside also.
yes, my lord.
Three places.
Start from Mecca, thereafter, one bamboo garden there,
Yes.
police station.
And
then-
then, I think some order was passed in earlier. I think AB was rejected.
Yes, my lord.
Yes, my lord.
Okay. So what is the difference here?
Different, my lord,
He is also named accused in the FIR.
yes, my
in
lord.
second, my lord, I
It will
have,
be difficult then. There, what we found, this court found
Right.
that they need to be examined because they were the person who led.
yes, no, my
These
lord.
20%,
My-
of course, one main accused, one, he is the main accused. And then along with him, 20%,
my lord.
they led to some around 500 to 600. And then you see broke up all those, the hospital as well as the police station also.
Yes, my lord.
That was not authorized.
My lord, in my application, my lord, I have made a categorical statement, my lord.
Hmm.
That uh, uh, past occasion at Mecca, my lord, and thereafter bamboo garden, my lord, I was not present, my lord. Second police station, my lord, I was present much before the coming of the mob, my lord.
You clarified there before the police.
Yes, my
Give
lord, that's why
statement.
I'm before lordship, my lord.
And then they see, probably they by now must have come back. They have, on the basis of the CCTV footage also.
Yes, my lord.
Hmm.
That's why, my lord, I have made a categorical statement, my lord. In the medical also, my lord, I
No, no,
assisted the
your
police,
state-
my lord.
What I'm saying is your statement will not help if they have filed FIR and if they have found out that you were present. You were not present, your
Yes,
statement will help
I was,
when they have found.
Well,
You and I cannot change the fact, that situation which you were present there, even if you say so also. Even if you say 1,000 times also, I was not present, but then if they have found in the CCTV camera, can we change?
no, my lord, that can,
You need to be examined.
yet that's why, my lord, my humble, this is investigation period, my lord.
Hmm.
Now, at this stage, my lord, I believe there will be an investigation, my lord.
Yes.
I have made a categorical statement, my lord.
What interest the police has? They will do a fair investigation.
Yes, my
of
lord.
My lord.
That's why, my lord, my humble submission, my lord. When I have made a categorical statement, my lord, that my presence, my lord,
Where have you stated?
in my,
State before the police.
yes, my lord,
You state before the police, give a statement before the police. I was not present when they asked, interrogate in the. There, you just tell.
yes,
them.
my lord.
Hmm.
That's why today I before lordship, my lord. If my lord grant me interim protection, my lord, I will surely, my lord, appear before the IO, my lord. I will.
No, if you clarify before the IO, they will not arrest also. Have they issue any notice against?
No, not yet, my lord.
Then
That's why, my lord,
how are you, if you were not present, how do you then?
that's why, my lord. And
What is the basis for apprehension of being arrested? If you are not present, if you were not present, if you were innocent, and if the police has not issued any notice, what is the reason for your apprehension
I
then?
have, my lord.
Why you have come?
Yes, my name, my lord. My name is mentioned in the FIR, my lord.
Hmm.
I have a reasonable.
Maybe, but then they will not act
Exactly.
upon it. If mistakenly someone has mentioned, if the police has found that you were not present, even if you appear also, they will not arrest you. There
No,
is
my
no
lord,
ground for your
that,
apprehension.
my lord, always there's a present, my lord. FIR is.
You are innocent, but
Yes, my lord. I'm truly innocent.
police has no enmity with you, personal enmity with you.
No, no, but, on that day, my lord,
Hmm.
I have an argument with the IO, my lord, for not not registration of my FIR, my lord, pending since 3 months, my lord. On that day, I was before the in the police station, my lord, inquiry about where my FIR was not
You were
registered.
in the police station.
Yes, my lord. And this whole mob come in, my lord. And I
For
assisted
what purpose you were in the police station?
to inquire about not registration of my FIR, my lord. That was forwarded by my lord. I have annexed that also in
What FIR? Regarding what?
this, my lord. That I have annexed at page number, my lord, 35, my lord. My lord. This was forwarded by my lord, central, my lord. The body of the complaint is at page number 33, my lord. This is by my mother and my sister, my lord. Page number 33, my lord.
Was
Page number 33, my lord. Annex number 4, my lord. 33, my lord. My mother, my lord, and my sister was SL, my lord. That we raised lost complaint to the before the one stop center, my lord. That was forwarded to the police station, my lord. But that was not registered, my lord. Accordingly, on that day, I was making so delay, my lord. After lapse of 3 months, also, my lord, you are not registering, my lord. And that at that point of time, I have made a category statement, my lord. I have a argument with the some argument with the police present there, my lord. Now that way, my lord will see, my lord, in the past FIR, my lord, my name is not there, my lord. I am not named FIR, my lord. But secondly, in second FIR, my lord, absurdly, my lord, in continuation, my lord, my name has been reflected, my lord. So my humble submission at this is, my lord, it is already, my lord, 2 months past, my lord, since FIR was registered, my lord.
you should have actually gone to the police station
Yes, my lord, I have gone, my lord.
and given.
Oh, that day we have gone, my lord. On that day I have
Given
present
the
there.
given statement that on that day I was present, definitely I was present before the police station in connection with the other police,
No, my lord,
other case
mine,
regarding your FIR.
my lord, will-
Regarding your FIR lodged by you. This FIR lodged by, your name is?
this is by my mother and my sister, my lord.
Hmm?
My mother and my sister, my lord. My mother and my sister, my lord. My humble submission, will kindly appreciate one thing, my lord. I want to cooperate with the investigation, my lord. It is already 2 months past, my lord, since the registration.
What about the other cases, in case of the other accused person in the present case?
My
Any
lord,
one of them have granted?
no, AB is granted, my lord. And my lord, 2AB has been rejected.
Whether any one of them have thereafter, after rejection of the anticipatory bail, pre-arrest bail, have appeared before the police, give any statement?
My lord, that I have to take
I
instruction.
inform, my lord, they have surrendered.
Let us see the record then.
Yes,
Okay,
madam.
let us see the record, okay? We'll see the record. If there is nothing against you, we'll protect you, okay? Mr. El Parme, Land Council for the petitioner. The applicant filed this application under section 482 of NSS 2023, seeking pre-arrest bail, apprehending his arrest in connection with case number 41 of 2025 under section 61 within bracket 2, stroke 117 within bracket 4, stroke 191 within bracket 2 of ENS 2023, read with section 3 of the PDPP Act, the Prevention of Damage to Public Property Act 1984, and N to rowing PS case number 42, stroke 2025, under section 103, bracket 1 and 2, stroke 132, stroke 61 within bracket 2, stroke 33, stroke 190, stroke 191 within bracket 2 and 3 of BNS, read with section 3 of the PDPP Act 1984. If you notice, call for the scanned copy of the case diary. Since Mr. Puri, Lanet, Mr. Puri, you are a special PP,
Yes, my lord.
special PP,
SIT.
SIT. Is present and accept notice on behalf of the respondent, no formal notice, and the formal notice is waived. So, list this matter when can
When 26, my lord, 26 September.
26, okay.
That, my lord, this is interest available, yes, my lord, this is will be too late, my lord. My humble submission,
See,
let it
the
be on,
incident took place when?
yeah, on 2 months past, my lord, see. That time, my lord, my humble submission, at least I deserve, my lord.
26.
Interim protection.
Then, we'll, fix it on, can it be 22?
My lord,
Why 22? 22,
Twenty.
okay.
My humble submission, at this stage,
We'll
my
see
lord.
the record. Let us see, because it's been after 60, more than 60 days.
60 days, already,
It's, 5 more days.
there is no question of tampering evidence. There is no question of any influencing the diseases, my lord. I humbly believe, my lord.
I have no idea about that.
And how less.
Okay.
Item number 2.
For washing and setting aside of charge sheets number 13 of 2025.
Is it a joint petition?
No, Lordship. It's
Of-
on merit.
On content, on merit?
Of Balapur PS case number 19 of 2022. Here, Lordship, respondent number 2 is the informant who has lost an FIR against the petitioner. Lordship, both the informant and the accused, they had a commercial transaction, business.
Okay,
There is a business between the party, whereas there has been dispute regarding the finalization of bills.
okay.
For that reason, the respondent number 2 has filed an FIR, cloaking the entire dispute as a criminal offense. Lordship, may I take you to the FIR, Lord? Page number 30.
Yeah.
Page number 30.
Yes,
Mary.
Yes.
I, so and so proprietor A Enterprise, Balpung, West Tamil District, Arunachal Pradesh, company approached you with regards to lodging an FIR against Sri Adarsh Junjunwala, Chairman and Managing Director, JB Cement Limited, Guwahati, for fraud and cheating and not paying dues to me for rental of 4-wheelers provided for hire to the company. The details of the case are as given in the proceeding paragraph. First paragraph says that there is a dispute because of non-payment of dues. During October 2021, I was approached by Sri so-and-so, husband of
it's a non-payment or it appears.
non-payment.
Your Lordship, during, in this case, I don't understand why entire, the charge sheet has not been annexed along.
When
There was,
this was October 23,
yes,
Yes. and
I'll-
charge-
what is the status?
I'll just apprise your Lordship. He was granted bail and directed to appear before the IO on
Okay,
to certain date. He did not appear. The state had filed a cancellation of bail against him. It's also not been brought before your Lordship notice, your Lordship. Subsequently, after that, during the pendency of that application, he appeared and gave his statement, and thereafter the charge sheet was filed. Your Lordship, when he gave his statement, that has also not been annexed along here. Your Lordship, we've come to page number 38, your Lordship. It does not only reflects about non-payment of the bill, your Lordship. Page number 38, your Lordship. 38.
Hmm.
Your Lordship will see it starts from alleged accused Sri Adarsh Junjunwala being of
38 is last page of
the
something.
charge sheet.
But this is charge sheet,
Yes.
yes.
Alleged accused persons Sri Adarsh Junjunwala
Yeah,
being
where are you?
38, the first line, your Lordship. It
First
starts
line.
from the middle.
No, 38 is the last page of the charge
Charge
sheet.
sheet. Charge sheet starts from, if your Lordship will please, it starts from 33.
33,
Yes. Starts from 33.
yes. Okay,
I'm just
38 is
reading the conclusion because
the
the,
conclusion, okay. Under the above fact,
yes. No, your Lordship, not under, just above that, your Lordship.
above that it is,
Deployed it to the other side to minimize the financial
okay.
loss. Thereafter, alleged accused person Sri so-and-so, being the director of the UD Mining Network Service Private Limited,
Hmm.
did not inform the complainant about the shutdown of his factory and kept the vehicle retained from his company. Now, it had come
Okay, that-
only after the, during the investigation that though there was a FIR complaining that he had not paid his dues, Your Lordship, and therefore the FIR was filed, Your Lordship. Subsequently, during the investigation, it came to the notice of the investigation officer that the factory was way before closed. That was not intimated to the complainant, nor his bills were paid, Your Lordship.
okay.
And the vehicle that was provided to the company was retained in the company premise, Your Lordship.
Okay, so the case is charge sheet file, what happened? Any progress thereafter?
No, Lordship, only charge sheet has been filed now.
Any process issued?
No, Lordship, now trial will proceed.
Trial would proceed?
Yes.
No, that is what I'm saying. Process issued, you have been issued summon,
No, did that,
taking cognizance?
yes. It's already been.
Okay. We'll call for the then,
Yes, Your Lordship.
Can copy?
Interim protection, Lordship.
No, not at the
State-
moment, not at the moment. It appears, it sounds like something.
It's
Explain.
not like, Lordship, we have not paid any amount.
No, we'll see the record, you'll see that this was the case of 2033. We'll see
Yes.
the record.
Charge,
Now, at the moment, you will not be adversely affected.
charge sheeted only on 24/7 of 2025.
Okay, so thereafter, let them also, will not stop, not interfere with the trial at the moment. After seeing the record, we'll pass necessary order.
Lordship, after 41A notice was issued, he has submitted his statement as well. in
What is statement?
Replied,
Before the court?
41. No, Lordship, to the police. Whereas he has submitted that here is dispute.
No,
he
police,
paid-
now see, it has come before the court only.
Yes.
Now, unless, the court will issue notice or,
Definitely,
yes, someone to you. Okay,
Yes.
for your appearance only.
Yes.
Copy, you will be served with the,
For
or
that
copy.
purpose, Lordship, kindly stay the process till this.
No, not at the moment. After, let us see the record first, then we'll go ahead with the passing necessary order, okay?
Lordship,
Case of 2023.
23, but charge sheeted
so
on 25, and he has in 41A also, the delay on his 160 because of his health issue. Lordship, the same was recorded in page number.
That was complete, that after completion of
Yes,
investigation only they have
Please-
filed charge.
He's not from the.
And this was also delayed, it appears that filing of charge sheet also delayed because you did not give the statement on time.
Lordship, because of health reason. The same
Ah,
was,
see. Now, it was delayed because of you, and now you are praying. Wait for some time, okay?
Lordship,
Please. Hard, Mr. C. Gapso, Lani Counsel for the petitioner.
Lordship, Lordship.
Hmm.
This is a matter where we are willing to consideration.
Yeah.
But the problem is that they are not submitting the proper bills. And
Let us
other-
see the record, let us see the record. Because they have collected everything now, by now.
Yes.
Okay, let us see the record, we'll pass necessary order.
Kindly stay, Lordship, kindly stay the proceeding if any. Since it's already, it will not even, it will not hurt the.
This
respondent
petition
as well.
filed under section of the bar in our action. Sanida 2023. The petitioner is praying for setting aside. Where is the GR case we have mentioned?
मिलना चाहिए था वो मिलेगा तो
Now the case is no longer with the police.
yes.
They have registered the court, GR case. Where is that? Where have you mentioned?
Lordship, I have not mentioned that they have said this is the.
Then- That will remain. Which one is to be stayed then?
But-
Even if we stay also, stay the further proceeding by the IO, then the case before the court will proceed.
No, Lordship, you simply mentioned the Balcony PS case
What
number.
are you saying? You are advocate, and you yourself submit that the case has already been charged sheeted, it's before the court, cognizance taken, and you have not mentioned the case number. Which one is to be stayed?
Case number is Balcony PS case number 19 of.
GR case GR court का
GR case number.
Lordship,
We will ask them to just find out yourself. And then please, stay, find out and stay. How can that be? Stay has to be to some case, proceeding of some case number. Don't make such submission, huh? I think then in that case, even if your prayer is to be,
Your lordship may kindly fix this matter to otherwise.
amend it.
Yes, for amending
Because
of the
unless there is a prayer for
first item.
setting a case, it will be difficult. What, you want to withdraw and file again?
Lordship, I will amend. Lordship.
Entire thing will have to be amended again. The course title as well as the prayer. It's all the same. What do you want? You file tomorrow,
Yes, Lordship, I will file.
find out, file tomorrow. Okay. Mr. Gatto wants to withdraw this criminal petition with liberty to file afresh after making necessary corrections. The prayer is allowed. This criminal petition stands dismissed with liberty as prayed for. Okay.
Debrief.
Item number 4.
May I, Lordship?
Yeah.
Lordship, in this matter, I've been instructed the party have settled the matter. So they are no longer willing to pursue the matter further.
Okay, so you save 15,000 also.
I don't know, Lordship, how they have done. So this, we would like to withdraw this
Okay.
matter, Lordship.
Mr. V. Jamo. Respondent,
For the respondent,
okay. Submit that he had an instruction that the matter has been settled between the parties and wants to end for withdrawal of the appeal. Mr. A.K. Singh has no objection. A.K. Singh Land Council for the respondent has no objection. Staff. Let's pray for Kama. This appeal stands dismissed on withdrawal. Okay.
they,
Okay.
Item number 6.
The interim order passed earlier. They'll also stand vacated, huh? Okay.
Lordship, this matter was fixed on 8th of this month, Your Lordship, and I sought for 2 weeks of time and Honorable Court was.
Item 6.
Yes, Your Lordship.
Okay, you were to serve copy to the petitioner also. Have you served? Have you received the copy?
already received the, it was fixed
It
for
was fixed
admission hearing.
Your Lordship, this matter was fixed on 8th of this month, Your Lordship.
8th of this month.
And I mentioned the matter and I was allotted after 2 weeks time was given, Your Lordship. But how come it fixed today? I don't know, Your Lordship.
I mentioned it as
2
an
weeks time.
unlisted.
Yes, Your Lordship.
I mentioned it unlisted last week on Friday, Lordship. Because the item
Oh,
numbers,
okay. This
yes,
has come on mention,
yes, Lordship, unlisted.
unlisted,
Yeah, I mentioned it unlisted on Friday,
Friday.
to be
But this
listed
was
today, to be
fixed-
listed today.
It was supposed to be fixed after 2 weeks.
Item
Your
number
Lordship.
7 is fixed for today. That is the reason, because the councils are same here and the parties are also
No,
same.
no, the 6, you have mentioned 6
Yes, to be taken up today.
today,
Yes.
but it was fixed for after to be listed after 2 weeks.
Yes, Lordship, the reason why I have mentioned it on Friday to be listed it today,
Hmm.
because there's one another matter, which is item number 7.
Okay.
Same parties, same council, and it is related matter, not directly connected, but related matter. They are somehow connected to each other. So
Okay.
that is why I have requested, mentioned this item to be taken up today together. Because the other case, the item number 7, the date was fixed by themselves to be taken up on 15th, that is on today.
Okay, item
And
7 was to
otherwise-
be taken up today.
Yes, item number 7, that's a fixed matter.
Okay.
That is why I have mentioned it
But-
unlisted.
You want this matter, item 6 also to be taken up today?
Yes, yes, because 6 and 7, they are related and connected, and the parties are also same, the councils are also same.
So in item 6, probably they were to
The only question,
furnish you copy. Have you received the copy?
already received copies, it was fixed for admission hearing, Lordship.
Admission.
Yes. Lordship, the only
So,
question,
then what is the case?
the only question here is whether, the learned trial court, has justified in giving, compensation amounting to rupees 5 lakhs to the
Can it-
complainant.
One,
NY
in
case.
138 NIA, can the court pass order for the interest?
Lordship, court can pass for compensation. However, this interest,
Not interest.
but this interest falls within the category of compensation.
I have
There's a
no
specific,
idea.
there's a specific judgment to that effect. Lordship.
You have a.
Yes,
authority,
yes,
you have
Lordship.
authority.
Interest falls within the category of
You have the authority to
compensation.
know.
Yes. And in fact, in their petition, if you see, Lordship, they've also accepted this as an compensation. Lordship may kindly come to their petition. They have themselves accepted the criminal revision petition. Lordship can see from the very beginning in the course title. This is their revision petition. There itself, you can see, Lordship, revision petition under so and so, read with so and so, so and so. In the last line, intends to pay fine of compensation. They themselves have agreed that this order is in form of compensation. Page 1. In the last line, to pay compensation and against the order dated so and so by London. Thereafter, again, Lordship, in paragraph 2, page number 3.
But whatever may be, even if they says also, but then
Yes, I'll give,
whether the law permits.
yes, law. I'll submit that.
What exactly
Lordship,
the order, the impugn order says regarding these 5 lakhs?
Uh,
5 lakhs is interest. Now, even if they interpret in any
yes,
way,
Lordship may come to page number 20, annexure 1. The operational part is in page 25 and 26 there. Page number 20, paragraph 15. In the instant case, the accused has no scope for rebuttal of the claim of the complainant, as they have not only admitted a claim and issuance of the checks to the complainant, but also repaid substantial amount of the claimed check amount. Further, it is not overlooked that the accused took and held back 65 lakhs of the complainant for a considerable amount of time, and thus it is imperative to reflect the views of the Supreme Court in so and so. It is observed that they, considering the length of the trial and date of the issuance of check, it is necessary to
Page
avoid.
25.
Yes, page 25.
yes. Para 15.
15. Yes, 15, Lordship.
Yes.
In the instant case, the accused has left no scope for rebuttal of the claim of the complainant, as they have not only admitted the claim and issuance of the check to the complainant, but also repaid substantial amount of the claimed check amount. Further, it is not overlooked that the accused took and held back 65 lakhs of complainant for a considerable amount of time. And thus, it is imperative to reflect on the views of the Supreme Court in the case of so and so. It was observed that considering the length of the trial and date of the issuance of the check, it was necessary to avoid reasonable interest on the check amount, along with the cost of litigation. Next page, Lordship. In the light of above discussion.
Next paragraph.
Yes, next page, page number 20.
Okay.
In light of aforesaid discussion, I am of the considered opinion that the accused persons are guilty of the offense under section 138 of NI Act. The accused person shall pay 65 lakhs to the complainant. Any amount earlier made shall be adjusted from the said amount. Further, the accused person shall pay rupees 5 lakhs as interest to the complainant.
This is specific.
Yes. Now, Lordship,
Now you have received this 65 lakhs.
yes, I have received the
Okay.
65 lakhs.
Now only what is to be decided is regarding the 5 lakhs rupees as
Yes.
interest.
Yes, Lordship.
Now, the other question is whether in NIA case and
Yes,
whether
Lordship.
the learned
I'll come to
magistrate
that.
can pass an
Yes, Lordship. Yes, they
order
can.
for interest.
Yes, they can.
You have to
The
satisfy
judgment
that.
which I have submitted, yes.
Which one?
It's R. Vijayan versus Baby and
Okay.
another.
Hmm.
Relevant para is in page 265 paragraph 18, Lordship. 267 paragraph 18. May I read, Lordship?
Yes.
Having reached that stage, if some magistrate go by the traditional view that the criminal proceedings are for imposing punishment on the accused, either imprisonment or fine or both, and there is no need to compensate the complainant, particularly if the complainant is not a victim in the real sense, but is a well-to-do financier or financing institution, difficulties and complication arises. In those cases where the discretion to direct payment of the compensation is not exercised, it causes considerable difficulty to the complainant, as invariably by the time the criminal case is decided, the limitations for filing civil cases would be expired. As provision of Chapter 17 of the Act strongly lean towards a grant of reimbursement of the loss by way of compensation, the courts should, unless there is a special in all cases of conviction, uniformly exercise power to levy fine up to twice the check amount, here under bracket, keeping in view the check amount and the simple interest thereon at 9% per annum as the reasonable quantum of loss. Meaning thereby, Lordship, within the compensation, the interest also falls under it. Lordship, may I take you to para 20 further? Para 20, Lordship.
Yes.
One other solution is further amendment of the provision of the Chapter 17 so that where there is a conviction, there should be a consequential levy of fine of an amount sufficient to cover the check amount and interest thereon at a fixed rate of 9% per annum interest, followed by award of such sum as compensation from the fine amount. So basically, Supreme Court has also seen that interest, when compensation is given, it also includes the loss, the sufferings, the interest, everything all together will be said as compensation, Lordship. And in our case, learned trial court has taken the view of 9% as mentioned here. To take it
As
uniformly.
mentioned, 9%.
Yes, no, as mentioned in this judgment, as Apex Court has viewed that
No,
there
no,
should be
the
uniform.
trial court in the impugn order.
No, that can be calculated, Lordship, because the amount is 65
It
lakhs.
has to be specific. And then a justification has to justify the ground for or passing of this 5 lakhs. You have to justify this amount.
Your Lordship, I would like to submit that uh, still due to some personal difficulties, he could not be, he could not present before the court, Your Lordship. And moreover, in this matter, I was given 2 weeks time, Your Lordship.
2 weeks time, see, after mentioning, after giving you notice, it has come, but then leading counsel, what happened to him?
Due to some personal difficulties, she is out of station, Your Lordship.
Who is the leading counsel?
Jyoti Jonglodu, Your Lordship.
So if you see the record, on previous 3 occasions, they took adjournment, and that's for same reasons that the leading counsel is out of station. If
Your
once
Lordship,
he
in
can
this
come-
matter, I was at least 2 weeks time, Your Lordship, but within 1 week, it got listed, Your Lordship.
Need to dispose of, then you let your leading, when your leading counsel is coming,
After 23rd of this month, Your Lordship, any date after 23rd of this.
we'll fix it on 24th then.
previous occasion also, Lordship, they have
We'll fix
themselves,
it on 24, we'll dispose of the entire matter.
they have themselves chosen 15th of this month.
We'll fix it on 24th. Okay. But probably because NIA case, and then this also, is this in NIA case?
Yes, Lordship, and I guess, Lordship.
Probably interest. Court has to justify because interest is not allowed. As of course can pass. You have to come prepared.
Yes.
It appears, because only what we can do, it can direct the judicial magistrate to pass necessary order as per the in accordance with law.
From this very case itself, from our vision also, we can interfere that, interpret that, the interest is part of compensation only.
Since the substantial, the principal amount has already been paid, and interest probably act is not allowed. And they will also come along, come with the.
But
another
compensation,
ruling.
Lordship.
And then there is, I have, I know
Now, Lordship,
case, one or two cases, maybe that will be against you. So you have to, I think, specifically you have to come,
yes, Lordship.
come with the authority.
Yes, Lordship.
Hmm.
Either compensation or fine can be imposed.
Let
Now-
us, let them appear. Okay,
Lordship.
Mr.
P. Wangpan, Your Lordship.
Lana Council submits that the leading counsel, Ms. J. Jongluju, is out of station and therefore pray for the answer. Mr. H. Ape, Lana Council for the respondent, has agreed on the prayer made by the Lana Council for the petitioner on the condition that the marriage is fixed on certain, fixed on 24th, okay, to which the Lana Council for the petitioner has no objection. Accordingly, let this matter be listed on 24th for admission hearing. Okay.
Item number 7.
Also, Lordship, then, since the leading counsel is not there,
Same.
Item number 8.
Yes.
That was right on the last applicant that. Raising question about the judicial.
Jurisdiction of?
Substantive question of. Since it is a second appeal.
Yes. Yes, sir.
My.
Second appeal against the dismissal of the condemnation petition. How it can be maintained? Second appeal can be maintained. First of all, you have to satisfy this whether.
When my.
Just a minute now. Only one question. Whether the dismissal of the condemnation application is an interlocutory order or is a final order in appeal. The second appeal can be filed against the final order in the first appeal. Then.
When your appeal is dismissed at the appellate court on the ground of limitation, then it can be filed in the form of second appeal. Because first appellate court first appellate court letter has been saying that there is a delay of 4 days. That is the issue. Because London judge has already decided on marriage. When the matter is dismissed on technical ground, on the limitation period, then further there is no further procedure.
That is why the other day also, when it was listed, I have specifically asked you this question, whether the appeal has also been dismissed. Then second appeal will lie.
Automatically.
How it is automatic unless there is there's a word spelled out by the judge, judge.
That is the question is when
The condemnation application is an interlocutory application which has been disposed of in this case. Now hereafter, if the learned trial court pass an one sentence order in view of the condemnation petition, the appeal also stand dismissed. Then second appeal will lie. I understand, but then here is the case where that order has not yet been passed.
against the fix after practice and I will answer.
No. You have to satisfy today. Why it should be listed again and again only to discuss with you? Only to give you making this unnecessary argument. That is unnecessary argument only.
One limitation
application, condemnation delay application. Please assume that the main petition is. We will not presume it. Will not presume it unless there is a specific word, a specific sentence dismissing the appeal. We will not presume it. And then you see, you have still, see, there is a provision for filing a review also against this dismissal. Judicial doesn't, not, because revision is generally filed when there is a procedure against the dismissal of your condemnation petition. Condemnation application. The latter judge has already decided the merit. And review is, revision is generally filed against the irregularity in procedure. There is no such irregularity in procedure. Yes, yes, that cannot be because it has to be a jurisdictional error. I may be update the status of it. Whether that my appeal has been dismissed by the latter court on the basis of condemnation delay or not. Okay. But in any case, this against this condemnation. On the next. Otherwise, prove that the second effort doesn't lie. Unless then I think it has been already proceeded. You can always come after the report. Yes, by you can appeal. You can always come if the appeal has first appeal has been dismissed. But then this doesn't lie. What I'm saying is this doesn't lie at all. Has not been enforced. That is why not. Only the dismissal order of condemnation delay has been enforced here. I have to enforce that dismissal of the. Yes. On the basis of, yes, if that is enclosed, then second appeal lies. I may be allowed after that order. Already that is. The next, I will after. See. Even if that is dismissed also, that will be separately filed by way of RSA, not in the dismissal of the condemnation application. Not here. I'm telling you again and again. And then you are unnecessarily prolonging. But then if you want that you want to update and then keep it pending for some time, can grant you. But no point. It will always be better that you withdraw this, confirm from there, get the order, dismissal order of your appeal, first appeal, then come by way of second appeal before this court. That order is not here. You can't also. Okay. Okay. Mr. Tapa, line counsel for the appellant. Praise for listing this matter in after vacation. No point. No. List it accordingly after the vacation. Okay.
Item number 9.
May I please, Madam?
Yeah.
Madam, in the last occasion, Madam, the TCR was called for.
You are not received it yet here.
Yes.
Not received. Wait for some more time.
Today also, your lordship has directed to the parties to appear to examine the signature lordship,
Identified.
identify the signature lordship.
Identify what signature?
Lordship, on last occasion, lordship has raised some concern regarding the signature of the lordship, petitioner lordship. It is not tally signature with
Okay. What was this case about?
this joint petition lordship.
Joint petition.
Yes, lordship.
Yes.
Okay. So
They are supposed to appear before the lordship.
are they appearing?
No, Madam.
Petitioner.
Yes, petitioner.
But they were not called for, it appears.
Lordship,
No direction as such.
Lordship,
my lord, it was supposed to appear before the PP office, my lord. PP has to identify. Otherwise, my lord, it has been already identified by the court commissioner, my lord.
Court commissioner,
Yes, during the,
the court will accept anybody. Whether the court commissioner used to check Aadhaar or iCard
yes, my lord.
at the time of
Yes, during the time of swearing, my lord, the asked for I-card, my lord.
iCard.
Lordship, just now he informed me that they are coming and on the way, Lordship.
Otherwise, my lord, he will,
No,
Agreed to-
because this is not a trial court. Just this court, when the learned additional PB pointed out that signature is not tally with, then only we just indicated that no order as such. We only call for the scanned
CCA.
copy of the record.
Lordship,
Trial
the
court.
order in the record, Lordship, but Lordship has raised a concern, Lordship. It was Lordship has, by verbally, it was spoken, Lordship. Why it was not
Yes, that's
reflected?
no. So whether if the person, the identity of the person is confirmed, then probably record may also not be required. That way it
Yes.
was indicated.
yes,
Is it?
yes.
Is it so?
No, Lordship.
What, is it a serious case?
No,
No, my lord.
So that is why I'm
Case
saying,
was not shared, Lordship. Lordship just raised the
yes,
question
that is why I'm saying.
yes, Lordship.
And with that view only, probably that was indicated that if the identity of the person is sure, then in this case, in such cases, because you have annexed all these documents, statement also,
Yeah, Lordship, the signature of the Lordship.
signature
petitioner in
is
the,
altogether different.
yeah, different Lordship.
Hmm.
Their deed of agreement as
Yes,
well
yes.
as Lordship, the Jimma Lordship,
Mhm.
the different, that's why the Lordship has raised the question that
Mhm.
whether they are the same or not, Lordship.
So what do we wait for? The trial court record, and in the meantime, satisfy the
Yes, ma'am.
additional PP with the, and let the petitioner come with the, because with this signature, learned additional PP raised this question, because signature is altogether different.
Yes.
That which is not possible actually normally. So this was actually unusual, but we could see. So
Well,
in the meantime, let the petitioner appear and satisfy. And also, in the meantime, since the trial court record is still awaited, we can get it listed next week.
Lordship.
Which court? CJM, UPI?
CGM court, UPI, my lord.
UPI Lordship.
Okay.
My lord, in the, during the time of swearing, my lord, the officer is asked to wrote their full name. That's why the petitioner wrote
No,
their
not
full
only
name.
here, not only here. Not only here, but in earlier documents, FIR, agreement.
Agreement
We were
and,
not concerned about we were not concerned about the affidavit signed before this court. Yes, this is full name. And in the FIR different, agreement different.
in
Okay.
FIR, the only,
Mr. M. Doji.
Yes.
Learned counsel for the, Mr. M. Doji, learned counsel for the petitioner is present. Ms. El Hage, learned additional PP is also present. The trial court record is still awaited. In view of the above, let this matter be listed next week. Okay?
yes.
Issue reminder
Obliged.
for the trial court record. Of the trial court record. Okay.
Obliged.
My lord,
The
interim,
registry shall issue, registry shall issue reminder.
my lord, dear interim, my lord, may we continue.
The interim order passed earlier shall continue till then. Okay.
Item number 10.
Yeah.
This is a regular bail application.
Regular bail.
In this case, Your Lordship, the Honorable Court has appointed amicus curiae on behalf of the victim. This is the
Box of it.
Yes.
Legal counsel.
yes.
So,
Ji Doji.
However, it seems like,
Whether she appeared earlier?
Yes, he appeared earlier, Your Lordship.
Okay,
Prior to this proceeding, she was absent, Your Lordship.
okay.
Maybe
Now what do
so.
we do today then? How long he has been inside the custody?
more than 1 year.
Okay, what is the stage of the trial
Trial proceeding is going on, my lord.
proceeding? And
Yes.
the
Prosecution
victim-
witness has been examined.
whether the victim has been examined,
Yes, Your
Yes.
Lordship. Victim examined.
cross-examined and discharged. Okay, what remains then?
Your Lordship, the remains is, Your Lordship,
Is there material?
Your Lordship, it's not only confined to whether the prosecution witness or the victim has been examined.
No, no,
Your
no.
Lordship, there are other aspects are also
Yes,
which has
that
been
is what I'm saying.
laid down by the Supreme Court in X versus Rajasthan, my lord.
Hmm.
So if there is also a possibility of fleeing from the, Your Lordship, trial court,
Yes.
Your Lordship.
That is what
So,
I'm
yes,
asking.
Your Lordship. Now, if the victim has not been examined, the question would be yes regarding the manipulation or
Hmm.
influencing the victim also. But after the examination
After
of victim,
examination,
yes, Your
whether
Lordship,
they are-
they're fleeing from justice also.
Hmm.
And for the smooth proceeding trial, Your Lordship,
Hmm.
that aspect has to be looked into so
Right.
far as the judge versus Rajasthan
Right,
is
right.
concerned. And only in the event, Your Lordship, the Supreme Court has held that only in the event if there is a undue delay,
Hmm.
and that too not on the part of the accused,
Hmm.
then court would be justified in ordering the release of the accused
Hmm.
on the ground
Hmm.
that the accused's right for speedy trial has been infringed.
Hmm.
But here the trial has been proceeding properly. Your
Now
Lordship.
my query is,
Yes.
since the victim has already been examined,
Yes.
is there any material against the accused or
Yes,
commission of the-
victim, Your Lordship, the updated TCR has been called for, my lord. The victim has stated, yes, stated the incriminating against, sufficient incriminating against the accused, my lord.
then in that case, this question will come.
Yes, Your Lordship. And that too, Your Lordship will find in the Rajasthan case, my lord. I will read one paragraph, my lord.
Okay.
That over it, I've noticed two things. Either bail is granted after charge is framed and just before the victim is to be examined by the prosecution before the trial court. Bail is granted once the recording of the oral evidence of the victim is completed by looking into some discrepancies here or there in the deposition and thereby testing the credibility of the victim. We are of the view that aforesaid is not a correct practice that the court below should adopt. Once the trial commences, it should be allowed to reach its final conclusion, which may either result in conviction of the accused or acquittal of the accused. The moment the High Court exercises discretion in favor of the accused and order the release of the accused on bail by looking into the position of the victim, it will have its own impact on the pending trial when it comes to appreciating the oral evidence of the victim. It is only in the event if the trial gets unduly delayed, and that too for no fault on the part of the accused, the court may be justified in ordering his release on bail on the ground that the right of the accused to have a speedy trial has been infringed. Now, Your Lordship, the law, Your Lordship, it evolved to that extent, my lord. Now, only on the basis of the discrepancies made by the victim on the deposition, that will also not suffice for granting bail, my lord. The court has to see whether there is an undue delay or not, my lord.
Here in this case, Your Lordship, the CC was conducted on 28th November 2025. From since the court has on several occasions served the notice to the witness, Your Lordship, that is a complainant and victim, and they deliberately remain absent in the court.
Cannot be
However,
deliberate.
on that reason, Your Lordship, the Honorable
Where is
Supreme
the
Court
deposition probably? Deposition is supposed to be there, but deposition is not completed to be obtained.
And otherwise also, Your Lordship, the victim must be given an effective hearing, my lord, because on document, Your Lord. Yeah, that is all.
But then this, can you just find out if the victim's deposition is available? The first page is there, second page I couldn't. But in any case, of course, the victim should be given an opportunity, and this will again attract, or it will go against a notification of the High Court and division bench order.
Yes.
Here is the order, Your Lordship,
First page is there.
Your Lordship, prosecution witness. Examination of PW 1 and 2.
No, the victims
Yes, Your Lordship.
is there.
Yes, Your Lordship.
First page I have seen.
Your statement is not there, but order is there. I will find out the deposition also, my lord. This is the order on 24 July, my lord. She was examined.
No, she was examined.
Yes, Your Lord.
The first page is there. I have seen the deposition of the first page.
First
Deposition of the victim. First page is there. That is the introductory part. The preliminary examiner. Some query by the court. But her deposition is not done that one. It's up to page 7. 8 is not
Page
found.
7, my lord.
Hmm.
It's not placed properly.
Hmm.
7 is the deposition of victim, my lord. Mr.
So-
Thakur.
It should be in 8. 8 is not available.
Yes, page 6, 7, and 8. Not properly annexed, Your Lord.
Mhm.
Page 8 is missing.
So 8, the main part is missing.
Yes, main part is missing. Only the question of, as part 118 of the Evidence Act,
Hmm.
just to find out the competency. Only
Yes,
that part is
competency,
recorded.
that part is there.
That
The
part is-
main part is not there.
So also.
What we can do is that since the learning council, legal aid council is also not present.
Yes,
In the meantime, we can ask
Direct
for the
register.
complete
yes,
deposition. of-
deposition.
We can, if she has implicated, then what you have submitted. to
Yes,
that
Your Lord.
part.
Yes,
If there is nothing, then we can consider.
yes, Your Lordship. And that too, Your Lordship, even if there is a minor discrepancy, that will not suffice. It has to be directly affect the core of the prosecution
Right,
case.
right. But then, if there is a prima facie case against.
Yes, yes.
So then,
Your Lord.
so this is which court?
My Lord,
UPR.
the special court POCSO UPI.
UPR. Mr. Tigame, learning counsel for the petitioner. Mr. Tokinet, the learned additional PP. For the state is also present staff. The trial court report received. The scanned copy of the trial court report received is not a complete set. In view of the work, moreover, the legal aid counsel for the legal aid counsel for the informant stroke victim is also not present today. In view of the above, the matter stand adjourned. List this matter when?
Your Lordship, maybe on 23rd of October after vacation.
Above, in view of the above, and as prayed for, list this matter again on 23rd
Yes, October.
October.
Yes, Your Lordship.
Okay. October, huh? The whom to direct for this entire set,
Yes, to the registry, my lord.
the registry cell. Requisition for the complete set of the,
Yes. Your Lordship, maybe the updated,
then updated this year.
updated this year, that will be better.
Okay. Requisition for the updated this year,
Copy.
updated
Scan
scan copy
copy.
of the this year.
Yes.
Okay.
Obliged, Your Lord.
Item number 11.
Yes.
Has been called for lordship. Lordship, this bail application has been filed for release of the accused person in connection with ROPS case number 14 of 25 under section 21A 27 small a. Initially, it was registered under 27 small a. After thereafter, the 27 capital A has also been inserted in the present case. Lordship, the accused person was arrested on 6/4/2025, and since last 162 days, he has been in custody. And now the charge sheet has already been filed and trial has already begun. So Lordship, the sole ground for this application is
But since the trial has already begun, so during trial, the purpose of keeping the accused person in custody is not required. And moreover, the accused person need to prepare his defense, which is not possible while in the custody, Lordship.
27, what is the punishment in 27A?
Yes,
39.
it's small n, capital A
No,
also.
capital A.
Yes, Lord. This is 27A, it is regarding, Lordship, the punishment for financing illicit traffic and harboring offenders, Lordship.
Hmm.
Here, Lordship, the fact why this section.
What is the
27
punishment?
Punishment is for 20, Lordship,
10 years.
extend to 20 years and shall also be liable to fine which shall not be less than 1 lakh rupees, but which may extend it X rupees. Lordship.
Okay. And 29?
Abatement and conspiracy matter.
Abatement, Lordship.
Okay.
Here, Lordship, the purpose of inserting section 27 capital A is only that there was a transaction history in the CSP.
Okay.
The accused person is the authorized, is running a business of Lordship, business correspondent agent, CSP, transferring an amount to the personal individual because he is the authorized, he having a valid license, Lordship. And from his CSP, it was found that some amount of 3 lakhs amount has been transacted. For that purpose only, it was on mere doubt, Lordship, then section 27 capital A has been inserted against. But in the entire charge sheet, there is no any connection whether that amount was from the illegal peddling of drugs or not. It doesn't establish. And moreover, Lordship, nothing has from the accused person. But he has been arrested only because of the statement given by the other arrested co-accused person.
They were trying to please court also.
Lordship.
When they were intercepted, they were trying to flee the spot.
Yes, police inserted initially, Lordship, 2 accused. One, Kento Bagra and Sri Gumnyasira. They were the person who were found to be.
You are not the one
No, Lord.
who were caught in, from the vehicle.
No, Lordship, no, Lord. Lordship, subsequently, after arrest of these 2 persons,
Okay, they gave us a disclosure statement.
yeah, they discloses the name of other co-accused person. And that other co-accused person, again, they disclose my name, Lordship.
Okay. So thereafter, the police visited your place. Nothing was recovered.
Nothing, Lordship. Only some amount transaction history from my CSP, Lordship.
So in the FIR, your name nowhere appeared then.
No, Lordship, no, Lordship.
Okay.
Absolutely.
What about the persons who were arrested in
They have already, all the accused person, they have already been released on bail.
Okay, and so according to you, the main accused have been released.
Yes, Lord, really. So after filing of charge sheet, Lordship, I have filed a bail application before the learned special
Whether
judge.
you filed, okay, then what happened? Released
That it was rejected, Lordship.
on the ground?
On the ground saying that, Lordship, so many important main witnesses are to be examined. After examining the main witnesses, we will see whether your bail will be considered.
And then what about the other accused who
Other-
were arrested from the spot?
They all the accused, total 5 accused were arrested. All the of
When
them-
they were released? Subsequently after your rejection or,
no, prior to my bail application,
okay, although their bail was accepted, they were released and
Yes.
your bail was
rejected.
rejected.
Yes, Lord.
So that means you are more important than them.
Lordship. Lordship, at this stage,
Court
Lordship.
So,
Yes, my lord.
evidence put it.
Yes, your lordship, may kindly come to your lordship. The first obstruction is before my friend is the successive bail before this court.
Mhm.
Your lordship has already rejected this bail after filing of the charge sheet. Your lordship will find in page 50
In a, well,
in their
the petition.
petition, my lord.
This court has rejected.
Yes, my lord.
Okay.
So that too, your lordship, after perusal of the charge sheet, at that point of time, the charge sheet was filed. And interestingly, your lordship, the fact of the case is that prior to your lordship, the insertion of section 27A capital,
Mhm.
all the sections, my lord, because the punishment is below 3 years, my lord.
Okay.
So for that, my lord, there is no any question of rigor under section 37 will come for section 21A, 27A, small a. But when 27A capital comes, my lord,
Okay.
then 37 has to be looked into. Even your lordship, it has been clearly held by the Supreme Apex Court that the power of the High Court or the Session Court has been curtailed drastically, your lordship.
What happened?
Your lordship, the power to grant bail during the period before your lordship conviction.
Okay.
Throughout the trial, your lordship, this condition has to be looked into before granting bail.
Mhm.
The first is the court has to find its satisfaction that there is a reasonable ground to believe that the person is not the guilty of the offense. And the second part, while on bail, he is not going to commit any offense. If either of one condition is fulfilled, or even if either of one of the condition is not fulfilled, the rigor will operate and he will not be entitled for bail. This is the law, my lord. And there are Ketina of judgments are there, my lord. Lordship, as your lordship is aware that in NDPS case, especially
Not less than 10 years.
yes, your lordship. Your lordship will find your lordship for better understanding. Your lordship may kindly come to section 37, my lord.
It's not,
Specific
NDPS.
specific, yes, NDPS.
because there's a minimum.
There are many cases, your lordship. In the Papu Ranjan case, your lordship, he was under incarceration for 5 years, and that too it was not taken into consideration by the court, your lordship. Here in this case, not even.
Here, last PIT NDPS is applied.
Sorry, your lordship.
PIT NDPS. Prevention of this weather. PIT NDPS.
Section 30,
Prevention of illicit transaction.
section 30.
Protect drug and psychotropic substance.
So perhaps your lordship, here the person is not been notified yet, your lordship. In Assam, your lordship, the certain notifications are there against an accused who are indulged in a narcotic substance, your lordship. They will be declared. But here in this case, your lordship, as on that we don't have any record against him that regarding the notification. But your lordship may kindly see section 37, your lordship. May I read, your lordship?
Yes.
Okay.
Yes.
Your lordship, the non-obscenity clause, notwithstanding anything contained in the Code of Criminal Procedure 1973-2 of 1974, A, every offence punishable under this section shall be cognizable. B, no accused of an offence punishable for offence under section 19 or section 24 or section 27 capital A, and also for the offences involving commercial quantity shall be released on bail on his own bond unless, first condition, the public prosecutor has been given an opportunity to oppose the application for such release, and second, where the public prosecutor opposes the application, the court is satisfied that there are reasonable ground for believing that he is not guilty of such offense, and second is that he is not likely to commit any offense while on bail. And now subsection 2, the limitation on granting of bail specified in clause B of subsection 1 are in addition to the limitation under the Code of Criminal Procedure 1973-2 of so and so, or any other law for time being in force on granting bail. Now, your lordship, the the conditions, the principles which are also to be looked into in the general law, that is also to be taken into consideration in addition to section 37. Now, interestingly, Your Lordship, in earlier when the accused approached this court, he has not disclosed regarding the antecedent. Actually, one POCSO case is pending against him also.
Okay.
So that has been considered by the special court, my lord. Prior to that, they have not disclosed this offense before this court. Because, Your Lordship, the section 438 and 439, it deals with the bail, same chapter. The conditions are same. Only distinction is one is pre-arrest and what is post-arrest. But the condition of 438, 437, 439 will be considered as a whole. That it has to be looked into that whether there is a prima facie case in all the sections. Second, the nature of the allegation, the gravity of the punishment if convicted, antecedent, Your Lordship, whether there is any prior case pending against the accused or not. And recently, Your Lordship, the Supreme Court has given stress to that aspect that even in, Your Lordship, SLP, after SLP, Your Lordship, even High Court has been directed that antecedent has to be implemented in, Your Lordship, their petition, Your Lordship. So here, only after rejection by the special court, it was come to our knowledge that POCSO case was also pending against the accused, Your Lordship. And so far as, Your Lordship, section 37 is concerned, Your Lordship, there are few judgments, Your Lordship. Yet enough judgments are there, but Your Lordship, I will rely some of them. And Your Lordship, one more aspect is there. What will be the change in circumstances? The mere change in fact is not amounting to change in circumstances, Your Lordship. And even the cosmetic change will not suffice, Your Lordship. Like filing of charge sheet cannot be equated with the change of circumstances. The sine qua non is, my lord, the allegations.
Yeah.
Now, my lord, this is on
Para?
section 30, my lord, 5 and 6.
5 and 6. Yes.
5, the first part is the explain the 37. Now 2, Your Lordship. The limitation on the ground of so and so, that is the addition. But now, Your Lordship, from the purpose for which the act was enacted and the menace of drug trafficking which it intend to curtail is evident from its scheme. A perusal of section 37 of the act leaves no doubt in the mind of the court that a person accused of an offense punishable for term imprisonment for 5 years or more shall generally be not on bail. Negation of bail is the rule and is grant an exception under subsection subclause 2 of clause B of section 37(1). For granting the bail, the court must, on the basis of the record produced before it, be satisfied that there are reasonable grounds for believing that the accused is not guilty of the offense with which he is charged, and further, he is not likely to commit any offense while on bail. It has further to be noted that the condition for granting the bail is specified in clause B of subsection 1 of section 37 are in addition to the limitation provided under the Code of Criminal Procedure or any other law for the time being in force regulating the grant of bail. Liberal approach in the matter of bail under the Act is Now 6, my lord. In Maktul Singh versus State of Punjab, this court considered the scope of section 37 along with the scheme of the Act and held the only offense exempted from the purview of the aforesaid rigor on the bail provision are those under section 26 and 27 of the Act. The former is punishable up to a maximum imprisonment for 3 years and the latter up to a maximum imprisonment for 1 year. For all offenses, the court power to release an accused on bail during the period before conviction has been thus drastically curtailed by providing that if the public prosecutor opposes the bail application, no accused shall be released on bail unless the court is satisfied with a reasonable ground to believe that he is not guilty of the offense. To the same effect are the judgment of this court in intelligence officer so and so, so and so. Now, Your Lordship, this is regarding the rigor of section 37, Your Lordship. The part 2 condition has to be fulfilled in any case, Your Lordship. And Your Lordship, now so far as Your Lordship, the successive bail is concerned, the sine qua non, what is the basic requirement for keep the petition maintainable, to make the petition maintainable, Your Lordship? This is, Your Lordship, the full bench judgment of the Your Lordship, Kolkata High Court, my lord. There, Your Lordship, this aspect was discussed. It was reported in 2002 SCC online, Kolkata, page 451.
Para?
Section, oh, para, my lord, page 21, my lord. Para 21, sorry. Para 21.
Yes,
Yes, may I read, my lord?
yes.
We have heard the learned advocates of the respective parties. We have also gone through the judgment referred to above. We find sufficient merit in the submission of Mr. Kaji Safiullah, learned public prosecutor, and Mr. Moitra, learned additional public prosecutor. We do not find any reason to differ from the view of the earlier division in the case of Kalidas Mitra, reported in so and so, and are in respectable agreement with the view expressed therein. We are of the view that entertaining a second application for anticipatory bail would amount to review or reconsideration of the earlier order passed by the division bench having coordinate jurisdiction, as the acquisition remain unchanged, my lord. Acquisition. We also find merit in the submission of Mr. Moitra that the acquisition being the sine qua non and since remain the same, there cannot be any revival of reason to believe or apprehension of can be considered by the court in the earlier application for the anticipatory bail. My lord, there must be a change in circumstance. The sine qua non is, my lord, the allegation and the acquisition, my lord. Accordingly, the first question under the present reference is answered in the negative. We are of the view that the second application for anticipatory, even if new circumstances develop after rejection or disposal earlier application, is not maintainable, my lord. So only the fact that there is a certain development that even if the recording of the deposition, my lord, that will not suffice. There must be a variation in the allegation in the deposition, my lord. And that too with the former one, my lord. And now the second part from your lordship, second one is from the full bench of the Rajasthan High Court, my lord. Para 17 and 20, my lord, this is was reported in 2005 SCC online, Rajasthan 319. Para 725, my lord.
Yes.
Having scanned the language of section 438 and 439 CRPC, we find that there is no substantial difference between section 438 and 439. As regard the appreciation of the case as to whether or not a bail is to be granted, the only distinction is that in a case under section 438, the person who approached the court apprehend that he may be arrested without any basis, whereas under section 439, such person approached the court after his arrest. Evidently, the power of anticipatory bail does not flow from Article 21 of the Constitution, but it has been conferred by the statute enacted by the Parliament, whereas provision contained in Section 439 flow from Article 21 of the Constitution of India. If the bail application of the accused under Section 439 is dismissed, once he moved second and successive bail application on the ground of substantial change in fact situation between the earlier bail application and the subsequent one, but filing of second and successive bail application on the basis of new argument and new twist on the same fact cannot be encouraged. Speedy trial is a constitutional right of the accused provided to him by the Article 21 of the Constitution. If the first application of the accused who is in custody is dismissed on merit and the trial is has a right to make second application on the ground of delayed trials, Section 439 related to the constitutional right of the accused, whereas Section 439 is an statutory right. The provision of Section 439 should not be put to abuse the instance of unscrupulous accused. Now, my lord, come to para 25, my lord. The ultimate conclusion. May I read, my lord?
Yeah.
In the ultimate analysis, placing reliance on the ratio indicated in Kalyan Chandra Sarkar case, Supra, we hold second or subsequent bail application under Section 438 CRPC can be filed if there is a change in fact situation or in law which require the earlier view being interfered with or where the earlier finding has become obsolete. This is the limited area in which the accused who has been denied bail earlier can move a subsequent application. Second or subsequent anticipatory bail application shall not be entertained on the ground of new circumstances, further development, different consideration, some more detailed, new document, or illness of the accused. Under no circumstances or successive anticipatory bail application shall be entertained by the second judge, additional session judge. My lord, here, my lord, I have given stress on section 438 and 439, my lord. That we shouldn't be confused that the jurisdiction with the consideration is same, my lord. The only difference is one is pre-arrest and what is post-arrest, my lord. But the material to be considered is the allegation, your lordship, sine qua non. And your lordship, the judgment which has been reiterated here is the Kalyan Chandra Sarkar, my lord. I will rely the judgment. That was specifically on, my lord, on successive bail, your lordship, as well as on incarceration, your lordship. Your lordship, this is 2005 to SCC, 42 page number.
Yes.
First para, my lord, I will rely and 20. Para 19 and 20.
Yes.
The principle of res judicata and such analogous principle, although are not applicable in criminal proceeding, still the court are bound by the doctrine of judicial discipline, having regard to the hierarchical system prevailing in our country. The finding of a higher court or a coordinate bench must receive serious consideration at the hand of the court entertaining a bail application at a later stage when the same has been rejected earlier. In such an event, the court must give due weight to the ground which weighed with the former or the higher court in rejecting the bail application. Ordinarily, the issue which has been earlier would not be permitted to be re-agitated on the same ground, as the same would lead to a speculation and uncertainty in the administration of justice and may lead to forum hunting. Para 20. The decision given by the superior forum undoubtedly are binding on the subordinate forum on the same issue, even in bail matter, unless, of course, there is a material change in fact situation calling for a different view being taken. Therefore, even though there is a room for filing a subsequent bail application in case where earlier application have been rejected, the same can be done if there is a change in fact situation or in law which require the being interfered with or where the earlier finding has become obsolete. This is the limited area in which an accused who has been denied bail earlier can move a subsequent application. Therefore, we are not in agreement with the argument of the learned counsel for the accused that in view of the guarantee conferred on a person under Article 21 of the Constitution, it is open to the aggrieved person to make successive bail application even on a ground already rejected by the court earlier, including the apex court of the country. Now, my lord, may kindly come to the lordship this on income. Refer para 8 and 18, my lord. Para 8, my lord.
Yes.
May I read it? On so and so, the accused respondent moved the 8th bail application, which came to be allowed by the High Court by its order dated so and so, solely on the ground that the accused respondent had undergone incarceration for a period of 3 years, and there was no likelihood of trial being concluded in the near future, and an appeal filed against the said grant of bail came to be allowed on the ground that the High Court could not have allowed the bail application on the sole ground of the delay in conclusion of without taking into consideration the allegation made by the prosecution in regard to the existence of prima facie case, gravity of offense, and the allegation of tampering with the witness by threat and inducement when on bail. This court held that since the above factor go to the root of the right of the accused to seek bail, non-consideration of the same and the grant of bail solely on the ground of long incarceration vitiate the order of the High Court granting bail. This court also observed that though an accused has a right to make a successive bail application for grant of bail, the court entertaining such subsequent bail application has a duty to consider the reason and ground on which the earlier applications were rejected. And in such case, the court also to what are fresh ground which persuade it to take a view different from the one taken in the earlier application. This court is in that order also found fault with the High Court or not recording any fresh ground while granting bail and for not taking into consideration basis on which the earlier applications were rejected. The court emphasized in the said order that ignoring the earlier order of this court is violative of the principle of binding nature of the judgment of the Superior Court, rendering in lease between the same party, and noted that such approach of the High Court in effect amounts to ignoring or overruling and thus rendering ineffective the principle ensuated, especially of the superior courts. On this basis, the appeal of the complainant challenging the grant of bail came to be allowed, cancelling the bail granted to the respondent. The order of this court is reported in Kalyan Chandra Sarkar versus Bapuranjan. Now, Your Lordship, para 18, my lord. 1/8, my lord.
Yes.
It is strict law that personal liberty cannot be taken away except in accordance with the procedure established by law. Personal liberty is a constitutional guarantee. However, Article 21, which guarantees the above right, also contemplates deprivation of personal liberty by procedure established by law. Under the criminal law of this country, a person accused of offense which are non-bailable is liable to be detained in custody during the pendency of trial unless he is enlarged on bail in accordance with the law. Such detention cannot be questioned as a violative of Article 21 since the same is authorized by law. But even persons accused of non-bailable offense are entitled to bail if the court concerned come to a conclusion that the prosecution has failed to establish a prima facie case against him, and or if the court is satisfied that in spite of the existence of prima facie case, there is a need to release the such person on bail, where fact situation require it to do so. In that process, a person who application for enlargement on bail is once rejected is not precluded from filing a subsequent application for grant of bail if there is a change in the fact situation. In such case, if the circumstances then prevail require that such person to be released on bail in spite of his earlier application being rejected, the court can do so. So now, Your Lordship, here in this case, the earlier, Your Lordship, will find in the earlier order it's clearly reflected, Your Lordship. The charge sheet was already filed, Your Lordship. And allegations and the material against the accused has been considered. In fact, Your Lordship, the additional allegation is the pending POCSO case against him, my lord. That was, in fact, not considered at that point of time. Now, the allegation, Your Lordship, it not lessening, Your Lordship. It's rising, my lord. So, Your Lordship, that has to be taken into consideration. And he is perhaps under has not completed, or he's perhaps under 180 days. My lord, here in this case, for incarceration of even 3 years has not been taken into consideration by the FX court, my lord. Even Article 21 has been given its rest, FX court. So in my humble submission, my lord, his bail may be rejected, my lord, considering this the allegation against the accused, and that to one more additional allegation, and that is one of the aspects which has to be taken into consideration while considering the bail. And Your Lordship, so far as the settled position of law on Article Section 37, and so far as on the successive bail, that much.
In the earlier bail rejection, whether this POCSO Act has been.
No, my lord, that is not
yet.
not, Your Lord.
Now this is new.
Yes, Your Lord, that is new, and that too we come into know from the rejection order by the session court.
So the trial court has rejected bail after the rejection of this by this court.
Yes, my lord.
Okay.
They again went there, then again they came back here.
Whether that rejection order has been enacted.
Yes, Your Lord. Your Lordship has rejected the bail on 18/6/2025, and the special court has again, Your Lordship, rejected his bail on 22/7/2025, my lord.
Okay.
Page, my lord, 56. Page 56
Then
onward.
after that.
Yes, after that, and my lord will find in page 58 that specific portion, my lord. Third last paragraph. Further, it is pertinent to mention here that another POCSO case pending before this court, which is at final stage, my lord.
Okay.
Only then, Your Lordship, it is come to the knowledge of the trial court.
Here in this case.
Yes.
In this NDPS case, whether evidence adduced or the deposition recorded.
Yet not.
Witnesses
At the initially.
examined, how many witnesses examined by now, till now?
Yet not. Not yet examined, Your Lord.
Not yet examined
Yes.
one.
So now it is not a fit case to release the accused.
Okay.
Now, Lordship, the next been, I exactly don't remember the date, but cognizance has been taken,
Okay.
and
Then-
someone has been issued to the
Someone issued
witness.
for- Oh, to the witness.
To the witness.
Witnesses. Okay. That would be a little difficult in the hearing. That the other case is also in the final stage.
Finally, stage, Lordship, the other about the POCSO case, Lordship.
Hmm.
the pendency, Lordship, does not preclude the applicant.
That is
accused
true,
person.
that is true, I understand.
And then regarding the subsequent, what my learned friend, learned additional PP has raised the issue regarding the subsequent bail. There can be two stages, Lordship, where the new development of new facts and circumstances that could be in the stages where the investigation is going on, Lordship. But this is a case, Lordship, where the charge sheet has been already laid before the trial court.
Right.
The question of changing in the case and about the allegation against the accused person, how that can be possible, Lordship. And Lordship, the learned trial court has rejected basically on the ground that the field examination of main witnesses, Lordship. There are, Lordship, more of a total 20 witnesses has been given by the investigating authority. Now, Lordship, out of 20, Lordship, who is the main accused? And
Okay, so that 1, 2, 3. This is 4th subsequent bail application, it appears.
I think this is
And earlier rejected and thereafter this court also rejected and
yeah,
thereafter.
then again, yeah.
Yes, sir.
The regarding, Lordship, rejection of this bail application by this honorable court, what happened, Lordship? The first bail application was moved before the learned special judge.
Yes.
It was rejected
Hmm.
on the saying that the case is at the very initial stage. Then again, they approached before this honorable court. And during pendency of that bail application, Lordship, the subsequently charge sheet was filed.
Okay.
And on considering the fact of the nature of the allegations, the bail application was rejected. Then after filing of charge sheet, Lordship, it was a new ground for the accused person. Because the first bail application before this honorable court,
Okay.
the filing of charge sheet was not taken as a ground. Then accordingly, after filing of charge sheet, the fresh bail application subsequent, but fresh ground was taken and approached before the special judge. And again, it was rejected, Lordship. Now, Lordship, I would like to rely on some judgment where the stages of the after filing of the charge sheet, the keeping of accused in the custody, Lordship, is violation, as well as he is not given opportunity of prepare his defense, Lordship. Alok Kumar, Lordship, of our own principal seat, Alok Kumar versus CBI, Lordship.
Alok Kumar.
Alok Kumar versus CBI,
No, this is decision of,
our own principal seat, Guwahati High Court, Lordship.
okay.
Bail application 1940 of 22, para 9, 10, 11, small para, Lordship. Para 9, Lordship. Page number 7.
Yes, sir.
Para 9. Page 7, Lordship.
Yes.
May I read, Lordship?
Hmm.
In the case of Prahlad Singh Bhati versus NCT Delhi, reported in 2001 for SCC 280, Honorable Supreme Court has called out the principles which the court has to consider at the time of granting refusing bail. The jurisdiction to grant bail has to be exercised on the basis of well-settled principles, having regard to the circumstances of each case and not in the arbitrary manner. While granting the bail, the court has to keep in mind the nature of the accusations, the natures of the evidence in support thereof, the severity of punishment which conviction will entail, the character, behavior, means and standing of the accused person, circumstances which are peculiar to the accused, reasonable possibility of securing the presence of the accused at the trial, reasonable apprehension of the witness being tampered with, the larger interest of the public or state, and similar other considerations. It has also to be kept in mind that for the purpose of granting bail, the legislature has used the word reasonable grounds for believing instead of the evidence, which means the court dealing with the grant of bail can only satisfy as to whether there is a genuine case against the accused and that the prosecution will be able to produce prima facie evidence in support of the charge. It is not expected at this stage to have all the evidence establishing the guilt of the accused beyond reasonable doubt. Then para 10 also.
See, this order also, more of this probably has gone against you.
Lordship,
Of course, the prima facie, then next period, Lordship, after filing of charge sheet, Lordship.
Okay.
This is regarding the prima facie against the accused person. And at the stages of consideration of the bail, Lordship, the evidence, entire evidence may not be taken into consideration. And para 10, Lordship, of the same
Of the same.
same judgment, yes. Regarding after filing of the charge. Keeping the above principles in mind, para 10, Lordship.
Yes.
Keeping the above principles in mind, now we will proceed to analyze the submission of the learned advocates of both the side and also the fact of the record and case diary so produced before the court by the CBI. I have carefully perused the petition and the documents placed on record and also perused the case diary so produced before the court, and I find the following. Sub para 1. The FIR was lodged on so and so. The accused was arrested on 14/6/22. The accused is behind the bar for last 84 days. And in my case, Lordship, it's 162 days. Then sub para 5, Lordship, next page, Lordship. From 1/5. The investigation of the case has already been completed and charge sheet has been laid before the Court of Learned Special Judge CBI Guwahati on so and so. The trial of the case is yet to be started. The charge sheet has been submitted citing 100 and referring as many as 161 documents. As such, there is no immediate prospect of conclusion of trial. And then sub para 9, Lordship, down below. Since investigation has already been completed and charge sheet has been laid before the court, there is no scope of hampering investigation or tampering the witnesses. Now trial will start and the accused has to prepare his defense. And as such, his further custodial detention seems to be not warranted as held by the Honorable Supreme Court in case of Sanjay Chand. Now this law, since in my case also, Lordship, in present case in hand, Lordship, the trial was not started. But in my case, Lordship, trial has already commenced. So, Lordship, I have to prepare my defense, which is not possible while in the custody, Lord. And there are numbers of judgment because Sanjay Chandra.
I think that is enough. Anything else?
Yes, Lordship. And Lordship,
What is this? The coordinate bench, BA 21-24. What do you want to from this? The another judgment you have placed.
well. And this is also the filing of charge sheet,
BA 21.
Lordship. Gaminate versus State of AP.
Yes.
May I take you to the para 17, Lordship?
Yes.
Para 17, Lordship.
Yes.
On perusal of the record, it is seen that the present accused is the first wife and the deceased was the second wife of the co-accused so-and-so. It is revealed from the record that on the evening of so-and-so, the accused had entered the house of co-accused so-and-so along with her first son, and thereafter she left the house around so-and-so. It appears that incident occurred after the present accused left the place of occurrence. The accused was arrested on Itna and is presently in judicial custody for last 104 days. The police has also laid the charge sheet on so-and-so and the trial of the case has already started. It is noticed that the investigation has already been completed and the charge sheet has been laid before the court. In my considered view, there is no scope of hampering the investigation or tampering of the witnesses. Now the trial has already begun and the accused has to prepare his defense, and as such, the further custodial detention of the present accused is not warranted.
My lord, on the judgment, my lord, the Sanjay Chandra Sarkar matter was relied, my lord. Actually, your lordship wanted the I appear in that case. Actually, that Sanjay Chandra Sarkar case was distinguished by the Supreme Court, but we were not in the position to apprise the court. Now, actually, I am getting an opportunity to your lordship to clarify that the Sanjay Chandra Sarkar, which was relied there, And according to the Chande Sardar case, my lord, the finding of the Supreme Court was the observation that refusal of bail to the unconvicted person will amount to giving him a test of, your lordship, imprisonment. So that was the actually observation in the Chande Chandra Sarkar, my lord. And now, your lordship, the case here is the distinguishable. Why? Because we are dealing with previous case. And that case was with 302. And Sanjay Chandra case was, my lord, distinguished by the Supreme Court, Honorable Apex Court in, my lord, this Viru, and I will give the citation, my lord, because this case has already been distinguished by the Supreme Court, Honorable Apex Court, my lord. Not overrule, my lord, but distinguished, my lord, basing on the fact. And that case was, my lord, distinguished in Viru Pakaspa Gauda and another versus State of Karnataka, reported in 2017-5 SCC 406. That Sanjay Chandra Sarkar case, my lord, which has been relied therein, that case was, your lordship, considered to be the correct law. However, my lord, considering the
Which one?
offense, my lord.
17-4 SSC.
My lord, this is with me, my lord. I will read, if your lordship allow, I will read out, my lord, and I will provide the copy, my lord.
Okay, provide the copy.
Yes, my lord.
With,
Section, actually, my lord, may I read the operating part, my lord?
in 2017-4 SSC,
Yes, my lord.
Page?
Page, my lord. 2017-5 SCC.
5,
5, yes, my lord. 406 page number.
para.
Para, my lord, para from para 12 to 17, my lord. Has been discussed, my lord, since it is distinguished, so it has elaborately discussed this case, my lord. Para from 12, my lord, I will read the operating part. On a perusal of the order, judge, we find that he has been swayed by the factum that when the charge sheet is filed, it amounts to change in circumstances. Now, your lordship, deal by this aspect. Change of circumstances. Needless to say, filing of charge sheet does not in any manner lessen the allegation made by the prosecution. On the contrary, filing of the charge sheet established that after due investigation, the investigation agency have found material has placed the charge sheet for trial of the accused person. As is further demonstrable, the learned trial judge has remained absolutely oblivious of the fact that the appellant has moved the SLP before court for grant of bail, and the same was not entertained. Be it noted, the second bail application was filed before the principal session judge after filing of the charge sheet, which has challenged in the High Court, and that has traveled to this court. This fact, unfortunately, have not been taken note by the learned trial judge. He has been swayed by the observation made in Siddharam Satlingappa Maitrek, especially in para 86, the relevant part of which thus read: the court, considering the bail application, should try to maintain fine balance between the social interest vis-a-vis personal liberty while adhering to the fundamental jurisprudence that the accused is presumed to be innocent till he is found guilty by the competent court. 13. The proposition expounded above has to be accepted, but that has to be applied oppositely to the fact of each case. A bail application cannot be allowed solely or exclusively on the ground that the fundamental principle of criminal jurisprudence is that the accused is presumed to be innocent till he is found guilty by the competent court. The trial court, the learned trial judge, has referred to the decision in Sanjay Chandra, my lord, that judgment, wherein a two-bench judge, while dealing with the bail, in bail application generally, it has been laid down from the earlier time that object of the bail is to secure appearance of the accused person at the trial by reasonable amount of bail. The object of bail is neither punitive nor preventive. Deprivation of liberty must be considered a punishment unless it is required to ensure that an accused person will stand his trial when called upon. The court owe more than verbal respect to the principle that punishment begin after conviction and that every man is deemed to be innocent until duly tried and duly found guilty. Now, my lord, where it is distinguished. Now, para 14. Be it noted, though the aforesaid passages from Sanjay Chandra's case have their relevance, but the same cannot be made applicable in each and every case for grant of bail. In the said case, the appellant accused was facing trial for offense under section 120B, 420, 468, 471, and 109 of IPC,
and section 13.2 read with section 13.1D of PC Act 1988. Thus, the factual matrix was quite different. That apart, it depends upon the nature of the crime and the manner in which it is committed. A bail application is not to be entertained on the basis of certain observation made in different contexts. There has to be application of mind and appreciation, score and understanding of the pronouncement in this field. Now, my lord, there also in the judgment, my lord, why it is distinguishable, the court was dealing with 302, and here also it was dealing with 302, but Sanjay Chandra Sarkar case was applied, my lord. But now we are dealing with the NDPS case where rigor of section 37 has to be looked into, my lord. The general law will not apply, my lord. General principle, my lord. So I'm just clarifying that. Otherwise, your lordship, I would not make submission on the Sanjay Chandra Sarkar case. Okay. I will furnish the copy of my lord this judgment, please. So, yes, anything more?
That's all, lordship.
That's all. Okay. So I'll pass order
Lordship.
and okay.
yes, sir.
It will be rejected or
Lordship.
abstain. There is some difficulties are there. Okay. This
Matter number 12.
Oblige, your lordship.
And lordship, small, if while rejecting the bail application, my lordship may direct the trial court for speedy the.
That definitely, that
Yeah.
definitely.
Yes, sir.
Otherwise, for last 3 occasions, they are on the appearance.
Yeah, but then you have also been approaching court time after. See, this is the fourth bail application.
Yes, yes.
For bail application.
But at this bail application, lordship, I have a ground.
What happened in the other case also probably your bail was rejected when he was arrested in connection with that Foxo Act.
Foxo lordship, I
He
have,
on bail. Okay,
Foxo lordship at the final stage, as per the
okay.
given by the
Okay.
special.
Oblige, your lordship.
Oblige.
Matter number 12.
My lord, I am for the petitioner, my lord. My lord. My lord, my petition, my lord, page number 46, my lord.
Yes. Yeah, this is item 12.
12, my lord.
Lordship, we have received the case diary,
Okay.
second copy of the case diary.
Mhm.
My lord, we already joined the investigation, my lord. That's what we are saying, my lord. And there is nothing, no allegation in the FIR against me, my lord. I am not the FIR named accused, my lord. I was the person, this person were the.
Listening also of the GST is also appearing.
Okay. Just a minute. Huh? This AB.
Yes, Lordship, AB Lordship. Yes, Lordship, in the case status, Lordship, the name of the applicant is also mentioned here, Lordship.
Received.
Yes, Lordship.
Yes, that was called for.
Yes, Lordship.
Just a minute. What is the allegation?
Lordship,
Allegation is that, my lord, we have annexed the FIR, my lord. Copy of the FIR is starting from page number 31, my lord. That is annexure P1, my lord. And the formal complaint is on page number 32, my lord. Continuing till page number 33.
Where is it?
Pardon, my lord?
Complaint?
Complaint is running page 32, 32. Well, it is against one Siddhi Vinayak Trade.
Where is the content of the
Merchant.
complaint? Where is the content of the complaint?
Malad, page number 32, Malad, paragraph number 12.
No, 32 is FIR, it's very small. Where is the content? Have you annexed?
Malad, we have not been supplied with that, Malad. Yes, Malad, page number 34 is there, Malad, one.
Lordship, may I, Lordship? The gist of the FIR, Lordship, is Lordship, I am explain, Lordship. That on 3/10/24, Lordship, at 21:30, that is 30, Lordship, a written FIR was received from the Inspector S.K. Pandey, with the tax and tax evasion, CGST and CX Itanagar Commissionerate, stating that during their investigation, credible information indicated that a firm named Siddhi Vinayak Trade Merchants had fraudulently obtained a GST ID using a forged rent agreement bearing a fake seal of JMFC Changlang, along with other forged documents, including an Aadhaar card, PAN card, and electricity bill. This fictitious firm subsequently raised fake.
Where from you are reading?
Lordship, this is the gist of the FIR, Lordship. I am reading
Gist
from this.
of the FIR.
Yes, sir.
Is it
Reading
with-
from the.
is it
yes,
Malad,
available
FIR
to
is
the
page number
public?
34, my lord. If my lord
This is the
kindly
Lordship,
comes, my
gist
lord,
of
the
the FIR,
complaint is there.
Lordship. This is the main Lordship, this offenses, Lordship, which is the Lordship implicated in the FIR, Lordship.
Okay, so that gist is not available before this court.
Lordship, this
Not
is
in
the.
the-
Malad, page number
Lordship,
34, my
yes,
lord.
Lordship.
34.
Yes, my lord. See, my lord, there is a complaint, my lord.
Complaint is 34.
Yes, my lord. Dated 3/10/2024, my lord.
Hmm.
My lord, see, my lord. May I read, my lord?
Yes, please.
My lord, there, it's starting, my lord, the first para, my lord, there has been an increased number of the fake firms in Arunachal Pradesh that submit forged and fake document to obtain GST registration. Subsequently, after obtaining the GST registration, they cheat the government exchequer by passing fake input tax credit ITC. The said phenomena has become endemic both within and outside of the state of the Arunachal Pradesh under the ambit of the GST. This menace has become a pan-India modus operandi, and Arunachal Pradesh has become a soft target of such miscreant to propagate such defrauding activities. This not only causes revenue leakage to the government, but also has a huge financial implication in the economy of the nation and the state in which such illegal activity gets a seamless passage. Well, these are the content, Malad. Then, my lord, there the Siddhi Vinayak Trade Merchant, the company came, the legal name is Rakesh Sharma. My lord, there, my lord, it's like it's registered across 11 states between October 2023, March 2024. To buy a fictitious firm on the strength of the fake invoices amounting to rupees 658.55 crores. A search was conducted under section 67(2) of the CGST Act 2017 by officer of the Anti-Aviation Branch, CGST and CX Commissionerate, Itanagar. However, the firm was found to be non-existent and the address mentioned in the PPOB, principal place of business, was found to be the fictitious as there exists no road with the name as put out in the address. Further, it was learned that to obtain the said GST registration, the said firm had submitted one rent agreement between Mr. Anil Singh, owner, 58 Complex Road, Lika Bali, Leparada, Arunachal Pradesh, and Mrs. Siddhi Vinayak Trade Merchant, though through its proprietor Rakesh Sharma. My lord, this name, my lord, Rakesh Sharma is coming, which was allegedly notarized by the JMFC Changlang. Number two,
Rakesh or Rajesh?
my lord, it is Rajesh, yes, my lord. And above, my lord, there was Rakesh Sharma, my lord. For starting, my
Rakesh
lord,
is also
one.
there.
Yes, my lord. Rakesh is also there, my legal name, my lord. Siddhi Vinayak. Just after that, my lord, Rakesh Sharma. My lord, in just number one, my lord. One second paragraph, my lord. Second line. And then over here, my lord, Rajesh Sharma, which was allegedly notarized by the JMFC Changlang. Number two, one electricity bill number this of the period of 1/1/2023 to 1/2/2023 tendered by the Likabali Electric Division. Number 3, the PAN card bearing number this in the name of Rakesh Sharma. The Aadhaar card bearing number this in the name of Rakesh Sharma. My lord, again this Rakesh is coming, my lord. Letter by the postmaster, Likabali Division and Executive Engineer Power, Likabali established that postal address and electric bill submitted with the house obtaining the GST registration were fake and forged. It is highly suspicious that the Aadhaar and the PAN card are also fake and forged. My lord, then, my lord, after that, CTC of all the documents above mentioned which were submitted on the GST portal to obtain the said GST number enclosed as Annexure P1, my lord, which is annexed in the FIR. On the further scrutiny, it was found that the late fees GST payment on the 4 occasions for the said firm Siddhi Vinayak Trade Merchant was made through one HDFC bank account inquiry. On inquiry, HDFC said the detail of the bank account number this was held with the HDFC Kasipur in Calcutta by a person named Sri Asutosh Kumar Jha. Well, having phone number this, email ID number this, a copy of the PAN number this, Aadhaar number this of the said person was furnished by the bank along with a copy of the AOF account opening form. On scrutiny of the AOF, it was found that this my lord, it is eligible to some part, my lord. Ward number this, village Banaras, PO this, again my lord, it's eligible. Bansara it is, my lord, not Banaras. Bansara, Darbhanga, per Pachari, Bihar this, and communication address was stated to be 4 Gopi Mandal Lane, Kasipur Road, Ramakrishna Math, Kolkata 700 this. However, on the bank statement furnished by the HDFC Kasipur, the addresses of the said person reflect to be care of Ashish Jha, flat number this, 3rd floor, this address, Howrah. On taking this up with the branch manager of HDFC Bank, Kasipur branch, and requesting him to furnish the document based on which such addresses were accepted to be his communication address, it was stated that at the time of the account opening, the former address was fed into their system on the basis of the local verification conducted by the staff of the bank, and thereafter the address was changed to the latter on the basis of the Aadhaar with updated address which was submitted at the branch for the address change. The copy of the Aadhaar with the updated address was provided to this office thereupon by branch manager annexed to the bank statement of Mr. Asutosh Kumar Jha was thoroughly analyzed, which revealed that not only 4 GST bank refer number late fees which were being looked for were there, but also there appeared 1305 other GST bank reference number to feature in the statement during the period this 2018 to 24. This led to believe that this person handled other GSTINs against which payment of the very nature have been made from time to time. Thereafter, extensive data mining was carried out on MIS portal to find the other GSTINs that might be associated with this person. It was found that the following GSTINs as stated in the table 1 were handled by Mr. Asutosh Kumar Jha in the different combination of the phone number and email ID belong to him or other. The investigation conducted by the undersigned and his team revealed that the SEC Form 1, Mr. Messer Siddhi Vinayak Trade Merchant with his proprietor Rakesh Sharma having GSTIN number this have cheated the government exchequer of a sum of 99.31 crore by passing fake ITC, and said GST registration was obtained by using forged document as true. Further, it is likely that the same firm had carried by one Asutosh Kumar Jha along with the others, and they are part of a larger nationwide gang which commit forgery to create GST registration, making bogus form and then cheat the public exchequer of a huge sum of money by passing fake ITC. You are requested to register. My lord, this was the complaint, my lord, which was registered, my lord. Then, my lord, I got one notice, my lord, from this my lord, it is in page number 46, my lord. To attain the investigation, my lord, that P3 of my petition, my lord, page number 47, my lord, there I have given one statement under 185 BNSS, my lord, there I have joined the investigation on the particular date which has been assigned, my lord. Then again, my lord, the petitioner has traveled to Itanagar, my lord, also submitted his willingness, my lord, on 1st September 2025. And prior to that, my lord, all the mail communication.
Just a minute.
Yes, my lord.
Sir, in the FIR, your name is not there.
Yes, my lord. My name is not there, my lord, and I am a businessman, my lord, who is maintaining this Asutosh Kumar Jha, and prior to him, Ashish Kumar Jha, my lord, who expired by road accident, my lord. My lord, that person used to maintain my account, my lord. They used to file my GST, my
Who
income
maintain your
tax, my lord.
account? Who maintain?
My lord, this Ashish and Asutosh, my lord. They are the
Okay.
chartered accountant by profession, my lord. My lord, that's how I was entangled in this, my lord, because I was in the good faith, my lord. They were maintaining, they were knowing each and everything of my every detail, my lord. Whatever they had did, my lord, how I will be answerable to that, my lord. And after the good officer who visited over here in Calcutta, my lord,
Okay, so,
yes, my lord.
notice was it to you? Page 46
Yes, my lord, 46, I have got the summon, my lord.
for your appearance.
Notice, my
And
lord.
thereafter?
My lord, page 47, my lord. Kindly come, my lord. It's running page 47, 48, and till 49, my lord. I have given a statement, my lord. There the officer came, inquired with me. He said me to write a statement, my lord, that I have did under section 185 BNSS. And then after that, my lord, GST sending some notices, my lord. On time and again, my lord, I was replying to that, my lord. I expressed my willingness, my lord, to come and join, my lord. That also I did, my lord. After this pendency of this matter also, on 1st September, my client went to Itanagar. He gave a document with a written and annexing all the summons and all the replies through mails over there that he will be coming. And again on 24, he is going to come over there, my lord. My few submission, my lord, I am a person, my lord, who myself is a victim, my lord. This Asutosh Kumar Jha and other person who have been arrested, my lord, was granted bail by this honorable court, my lord. And it was criminal petition number 188 of 2024, my lord. Where Asutosh Kumar Jha, Sonu Kumar Jha, Bittu Kumar Jha, Bipin Kumar Jha, they were granted bail, my lord. Yes, my lord.
You are basically,
Myself is Faiz Ahmed, my lord. My lord, I am
Faiz
running
Ahmed.
a company. Yes, my lord. I am running a company, my lord. And for that running a company, my lord, GST filing is there. Many income tax filings
What is
and
the
such
name of your
filings.
company? What is the name? What is the name of your
National
company?
Power, my lord. It is named by National Power. And National Power has not did any fraud, my lord. It is nowhere in the complaint. Neither myself, my lord. My lord, it is written in the page number 47 itself, my lord, the second line, my lord. National Power and Mega Plastic Work, which is the company of the
47.
Yes, my lord. See, my lord, it goes like this, my lord. I am I have in two firms, namely this National Power and Mega Plastic Works, my lord. My lord, these two name, my lord. It is nowhere in the FIR, my lord. Neither it is a subject of investigation, my lord. Till date, no notices have been served on this firm. My lord, and then it's running, my lord. And I have no knowledge of the Siddhi Vinayak merchants.
On of the notice from the police
Yes, my
under
lord.
section 35,
Yes, my lord.
so you have appeared before the police on
My lord, on the date which has been granted, my lord, it is written on page number 49, my lord, 14/1/2025. Page 49, 49. My signature, and
this
then
was
after that, my
issued
lord.
on 10/24/25.
Yes, my lord.
Okay, you appear in January.
Yes, my lord.
You
And my lord, see, my lord, page number 46, my lord.
statement was recorded.
Yes, my lord. Page number 46, my lord. Line number fifth line, my lord.
Why you are
Fifth
referring?
line.
Why you are referring?
My lord, see the
46?
date is there, my lord. 14/1/2025, the date which has been assigned to me to appear in this police station, I appeared.
14/1/2025.
Yes, my lord.
Yeah, may lordship, the statement which is recorded, this is not from the Itanagar PS lordship, this is under other PS lordship.
My lord, I agree, my
The
lord.
statement which they have lordship annexed in the page 47 lordship, it was not recorded before the Itanagar PS.
My lord, if
Itanagar
my
PS
learned
lordship, the
friend
notice
sees
was
that, my
issued
lord,
but they never appeared lordship.
my lord, if my learned friend see, my lord, it's running, it is like Maniktala police station. They themselves have said, my lord, you appear over there, I will record your submission. We are there in Calcutta for inquiring and arresting the people.
Just a minute. You were issued notice to appear before the IU Itanagar
There's no certified copy lordship.
Itanagar PS. And then you appeared on 14, the notice was issued on 3/10/2024.
Yes,
Isn't it? By IO of the case.
yes, my lord. My lord, see that fourth and fifth line,
Police station Itanagar, isn't it?
Yes, my lord, that was the case which was registered. My lord, I am reading page number 46, my lord. It
Just
will
a minute,
make-
just a minute. Learning
Yes,
Council, just a minute. Just answer the query. Okay, the notice was issued on 10.
3/10/24, my lord.
24, 3/10/24.
Yes, my lord.
October, November, December, January. And then you appear before the police in the month of January, 14 January.
My lord, prior to that, my advocate has went to Itanagar, my lord, submitted the documents there, my lord.
Hmm?
Prior to that, my lord, GST has supplied some notice, my lord, to which my petitioner's
No,
advocate went to.
Just clarify once. So notice was issued on 3 October 2024.
Yes, my lord.
Okay, so you, according to you, appear before the IO of the case on 14.
My lord, as the date was mentioned in the notice, my lord, to appear at Maniktala police station on 14/1/2024, my lord. I went over there.
Where this
My lord, I'm reading the notice, my lord. In pursuant to the subsection 3 of 35 of the BNSS 2023, I hereby inform you that during the investigation, ITA PAS number this under section this is registered at the police station Itanagar. It reveals that there are a reasonable ground to question you for to ascertain facts and circumstances from you in relation to the present investigation. Hence, you are directed to appear before me at 4 p.m. on 14/1/2025 at Maniktala police station.
Maniktala, where is this Maniktala
My
police
lord, it
station?
is in West Bengal, my lord.
Okay, this is the IO of the case that Itanagar has issued directing you to appear before Maniktala police station on 14.
Yes, my lord. Yes, my lord. And one IPS rank officer came for investigation, my lord. And in front of him, my client has given this statement.
Okay,
His name was
your statement at page 50, typed 1, has been
47, my
recorded
lord.
by the
47.
47 is handwritten. Your typed
Yes,
out,
my lord.
typed copy is at 50.
My lord, type copy of one page, my lord, because that was illegible. That's why we have typed one copy, one page.
Yes.
Yes, my lord.
Okay, you appeared. This is
Yes, my lord.
I had also golden alone. What is golden alone of? What is this? What he meant to say? This golden alone of.
My lord, between which one, my lord?
Can you read the typed copy at page 50?
Yes, my lord. But a loan which soon turned into, my lord, it was like that with this Sutos was offering me some loan, my lord, to run my business. I have taken, it was a personal loan, my lord. That chartered accountant has offered me to take some loan. That is nowhere related with this case, my lord. And I have repaid him. That Ashish Kumar Jha has paid, given me that loan.
I don't remember the legs. I don't remember the legs that I have attended to
Yes, my lord.
and talked to from so and so that I now learn belong to Rakesh Sharma. I
We will know.
had contact with the
Yes,
tutor staff, so his late uncle, from whom I had also golden. What is this? I have had also golden a loan. What is this?
might be some spelling mistake, my lord. It is like gotten a loan, my lord. It is like gotten a loan. I have got a loan. That's what he want to say, my lord. Also
Gotten?
had gotten a loan of around 4 to 6 lakh. That's what he want to say. It is his brother, Tabrez Alam, a cousin brother. He is also a business partner of his like firm. That
Loan
two
amount.
firm. Yes, ma'am. Basically, they have got a loan from Ashish Kumar Jha, who had died. This person are paying to his wife. Now the loan which he have taken, now they are repaying back. And in the
Ashish,
picture,
right.
this
Who was this Ashish?
Ashish was the chartered accountant who was actually filing this with everything for them.
Chartered accountant
Of the firm, my lord, we don't know, my lord. They are having some firm at Kasipur, which the HDFC bank is stating there that this was the address and all. Asutosh is his some cousin brother related with this Ashish. Ashish died on a road accident, and after that, this person came into picture, my lord. So they were filing their returns from last many years. So they said that after this, we are there to carry the work of this business. We will file your input tax credit and everything. So they said, okay, okay, we don't have any problem with your firm as we are doing for many last years. But like my client, my lord, there are thousands of clients, my lord, they are having, my lord. They are running a firm. So now on every form which they are filing, my lord, they will do like this. They will come under scanner. Well, let's see in the last page of my statement, my lord. I have stated, my lord, I am ready to cooperate with the investigation as and when I have
Yes.
will be called.
What according to you is the,
Lordship, I think counsel friend is not clear about the case. Is that initially the case is about the alert circular through the GST department. And that's different case against this person. That case is still under investigation.
Okay.
That's one case. And another case is there is a criminal complaint against this person, this Faiz Ahmed, for non-compliance of the summon. That's before the learned judicial magistrate UPA. And this person, Faiz Ahmed, has been summoned by the GST department in different occasion in the month of October 2024. Later on, what happened, after this inquiry and investigation, this department found that this in the Siddhi Vinayak trade merchant, this firm, it has been registered in Likavali, where all the documents were forged to register that firm. And subsequently, after examining all the documents, they found that there are numbers of transactions with people. And in that regard, there had been all the investigation has been carried out by this GST department. Meanwhile, this Faiz Ahmed has been summoned. But later on, this GST department doesn't have appropriate provision to punish them for the forgery of the document. Therefore, this, if suppose they had been implicated in GST law, then that they will be punished under section 132 of the GST law. And that's for availing input tax credit. So there is allegation against this person is that Faiz Ahmed is availing input tax credit. And this Siddhi Vinayak, that merchant, has issued more than 15,200 fake input tax credit, and that's amounting to 658 crore. So in that regard, later on, further investigation has been carried out, and there are racket being run there in West Bengal. And they have linked 11 states, where there are 11 states and prominent 58 firm. Out of that, this Faiz Ahmed firm, that Nation Power, is one of the prominent transaction is over there with this Siddhi Vinayak. Now later on, that's the reason means this FIR come up before the Itanagar police station for charge under 467, 68, 471 for forging the document to establish that fake firm. And that fake firm has been established in the 2024, and within a 6 months, they had availed the input tax credit around 99.8 crore. And they had issued the amount value of 658 crore. Now, main reason is that this person summoned by GST department also. Even the non-compliance of the summon criminal complaint has been filed before the judicial magistrate UPA. Now, this person is required for further investigation for that in this Siddhi Vinayak case. Now, what they are pleading that other accused, men accused, are on bail. Main reason is that their bail has been rejected 6 times. But main reason is that they could not complete their investigation. So that's the reason charge sheet could not be filed. So on default, they got bail. So now, if this person doesn't appear, then this thing will be continued. So that's the reason there is a requirement of custodial interrogation of this Faiz Ahmed. And as per the credential record, there are numbers of UPI transactions with this Siddhi Vinayak, and there are numbers of around 90 times this call telephonic record has been collected through the CDR. And as per this Faiz Ahmed's bank statement record also, they have some on record, they have some huge transaction that recently that was 18,38,165 rupees, and also 1,60,000. So those are the transactions which on record we can see, and apart from that input tax credit, that's separate case. So therefore, Lordship, if this person has been given interim, then definitely they will evade this investigation.
What
Well,
is
what
this?
my learned friend saying,
Statement
my
before.
lord,
He
on
has given
1st September, we
Lord-
appeared before
Lordship,
them,
that's
my
a-
lord.
His statement is also questionable. If you
My
see
lord,
lordship page number
my
47.
learned friend is saying, my
If-
lord,
Wait,
these
Mr.
are the separate thing and that is a separate
your
thing.
name?
That's what I am saying.
Wait. Why don't you listen? You have completed your argument, your submission. Wait for some time. Okay.
So
Just a
page
minute.
number 47, lordship.
Just a minute. This statement, he is stated to have given statement before the IPS officer on 14/1/2025. This statement was in connection with which case? In the present case?
Yes.
And a notice was also issued in the present case.
Yes, lordship.
So statement, you have all directed him to appear before Manila Police Station on 14/1/2025. Is it the case, the notice?
Yes, lordship.
Okay, so you have already recorded his statement.
Lordship, further investigation is still
No,
awaited.
yes. You have recorded his statement.
Yes.
Just answer me.
Yes.
Then what more you want? He is ready, he is cooperating, and you are recording his statement. As and when you direct, he is appearing.
Lordship, that we have to ascertain with the Lordship going to the Lordship properly, because Lordship, here Lordship, they have annexed Lordship, they have not properly Lordship, there is no
Not certified.
certified
No,
Lordship.
see, they, in the bail application itself, they have annexed here the notice issued by you
No, notice,
directing the accused to appear before the Maniktala police station on 14/1/2025. He has sincerely appeared and given his statement also. You have already recorded his statement. What more you want?
Lordship, statement was recorded by Lordship, but Lordship, whether it was recorded or not, that we have to
What
ascertain.
Bail application, have you not forwarded the bail application?
Lordship, this case study Lordship, because in the case study Lordship, it is there or not Lordship, because we have not found Lordship.
See, when
Yes,
they have
Lordship.
filed bail application with all these documents, you should have obtained instruction in connection with all this case, including the statement recorded. You should have asked them that, since it appears that they have already given you a statement. whether-
Actually, Lordship, this case study Lordship, just today only Lordship, we have
You
received
obtain
this case
instruction,
study.
obtain instruction, because
Lordship,
they
that
have-
will
he
do,
has already
Lordship.
given statement,
Yes, Lordship.
it appears.
Yes, Lordship.
And ask him that if, and he is ready to give his statement, whether he's
Custody
interrogation
interrogation.
is necessary or not.
Yes, Lordship. That will do, Lordship.
Don't submit just on the basis of all those, no? Because he has clearly stated that he has already given and he is ready to cooperate also. Now, under the circumstances, what is the necessary? You just obtain instruction, when do we?
Yes,
Tomorrow,
tomorrow,
day after
yes,
tomorrow.
Lordship, day after tomorrow.
Tomorrow would be the DV. Day after
Yes,
tomorrow.
Lordship. Day after
Okay.
tomorrow, for surely, Lordship.
My lord, meantime, my lord, some protection, my
Mr.
lord, against any coercive action, my lord.
Mr. Al Ansari, Ansari, Lani counsel for the applicant, applicant is present. Miss, Mr. Panjakipa, you are for,
Yes, informant,
hmm?
informant, yes, that's it.
Okay, Miss El Hage, additional PP. And Mr. Tikipa, representing the informant, are also present. So, Miss El Hage, Lani counsel, said, although this is what
But it is a case study, Lordship.
case there is.
Yes, Lordship. Actually,
Also,
Lordship,
received the
many-
case, but she is yet to obtain instruction with regards to the statement, with regard to the notice issued to the accused and the statement given by him.
Lordship,
whether
it will
was
be though, Lordship, properly, Lordship, this is GST, Lordship, standing counsel, Lordship. He also may be instructed to the,
No, both,
Yes.
because the query or the question, whatever comes from the
Yes,
court,
sir.
will be to both.
yes,
So whosoever, anyone can take the answer, who is answerable, okay? Now, obtain instruction with regards to the statement and notice to the notice to and statement and praise for some time. The prayer is allowed. Stop. Let this matter be listed again day after tomorrow. Okay.
My lord, no protection, my lord.
Day after tomorrow. So
Obvious,
we'll
my lord. My
consider
lord,
day
and
after
we
tomorrow.
have, my lord, we have went on 1st September 2025, my lord, to the GST office, my lord, which my learned friend is not having proper
So let them
instruction,
obtain
I think, my
instruction.
lord. Obvious, my lord.
Item number 13 and 14.
Yeah, item 11. Okay. I think nobody has come. Why? I think we have to continue at 2. We'll continue at 2. Okay.
Item number 13 and 14.
Yes.
Item number 13 is filed by petitioner. Me.
Not that file affidavit.
Uh,
You are for the? Okay, not yet filed. So, yes, 13. What do you want?
have received the order passed by the
Hmm.
wherein they have been restrained from filing DPS.
Okay.
Where this record may be called for.
Record was not called for, or not called for. Okay. So, Mr. Ambo,
Incumbents.
Kambo, Lami Council, for you are for?
In item 13, I am for the petitioner.
Okay, petition. And Mr. R for you, Lami Council for the respondent, are present. It is submitted that since the petitioner has challenged the order of the trial court, the record may be called for. The record would be necessary for consideration of the case. Okay. In view of the above, let the record, trial court, scan copy of the trial court record be called for. Okay. Mr. Koyu also prayed for allowing him to file, allow him further time to file affidavit. So, in view of the above, let the record be called for her. And list this matter after 3 weeks, giving in order to enable Mr. Koyu, planning council for the respondent also to file affidavit, necessary affidavit. Okay. So, oh, you're you are also here. Okay, in 14. 14 is different or same?
It's different. In item number 13, it was I have filed one title suit. During the pendency of title suit, my LPC was cancelled.
And you are challenging.
I am challenging the cancellation of my LPC in the present decision. They have filed their affidavit. I'm afraid that maximum may also be this after 3 weeks, so that filing.
Okay. Parties present. Mr. Koyulani counsel for the petitioner is present. Mr. You are for respondent number
Private respondent number 5.
5. And you are for respondent number 1. Okay. Mr. Okay. for 1 to 4, huh? Mr.? Yes, sorry, Mr. For 1 to 4 and Mr. Kamo for respondent number 5
5 and 6.
and 6 are present. Age rate for common list is matter along with CRP 37, 20, 22 after 3 weeks of
Lordship is including there.
here in 14 there is interim. The interim order passed earlier for 20 May till the next date of the
Your Lordship, in item 13 also there is interim.
same.
Yes.
Item number 15.
May I, my lord? My lord, I have been appointed as legal aid counsel for respondent number 8. So I need some time. Recently, I've been appointed, my lord. So I need some time to file an affidavit if required, so.
Okay, how many total, just a minute. Directed to prepare a table. Yes. So, let me just note, who else has filed affidavit till now? Bulang Marik,
Not yet.
not yet. Not yet filed. Takam Lang Deep,
Yes, sir.
file. Okay, file. Nirudas? Not yet. Dulal Basumatari?
Lordship, in respect of respondent number 3, 4, and 5, I also would like to take this opportunity to make some time, Lordship, to file my affidavit. 3, 4, and 5.
You want to file objection? Two,
Yes. 3, 4, and
Which
5.
two?
Dulal Basumatari, Dipali Basumatari, and Lakshmi Gaur.
Yes, my Lord, we have
File.
already filed. Yes.
File, okay. Tachi Anya? Tachi Anya?
My lord, I
You are for? Okay, not yet filed. Legal aid counsel. Okay, thank you. Okay, then Sushil Singh, file, already filed. Pushpa Mondal.
Your Lordship, yeah, I have already filed the objection.
Oh.
Yes, your Lordship.
Amang Kaya? Bama. Prasna, Millie, file. Not yet, okay. Nilamanga,
Yes, my Lord, we have already filed.
file, okay. Ridoni,
But, my Lord, one correction, Nila Manga is in respondent number 4.
is 4.
Yes.
Yes, Mr. Ganguly, can you hear me?
Yes, Lord.
Mr. Ganguly,
Yes, Your Lordship.
okay, you are appearing, Dulal
For,
Basumatari is respondent number?
4.
No, respondent number I'm told is Nilamanga.
No. The notice which was issued from the High Court Deputy Registrar, that notice shows Dulal Basumatari as respondent number 4, Dipali Basumatari as respondent number 5, and Lakshmi Gaur as respondent number 6. 4, 5, and 6.
Nilamanga, on what basis on what basis you are submitting Nilambanga as respondent number 4?
My lord, as per notice dated 21/05/25, it is in serial number, respondent number
Okay, that is,
on basis of
whether the respondent number has been mentioned there?
not exactly, my lord.
Not. So then you will be respondent number 13, it appears,
Yes.
as per the serial.
So, my lord, in that case, we may be allowed to that make correction in that objection we have already filed.
Okay, then Ridonime,
Yes, we have already filed.
fine, okay, your respondent number?
Respondent number in as per our record, respondent number 6 we have.
6 is again Lakshmi Gaur.
Yeah, that is contradict.
So, we do not know what is the number, accused number given in the trial court. Actually, it coincides.
Earlier, there was an order of the Honorable Court, arrange the manner the system.
Yes, yes, yes. So, you see, the rest of the, after 12,
There is a confusion in the notification matter. In the notification matter, severely arranged. And but matter the as per the petition, it is not yet matter arranged. Therefore, there this Honorable Court has given a directions to the registry.
yeah, last occasion.
We
So,
don't
but
know,
then
still, there has not been published.
this copy table has not been furnished to the council.
Yes.
Yes.
The table should, because this should be given to the parties also.
Yes, so that it can be easily identified.
Can you? Because this has also been only up to 12. Not yet impleted. Bamang Moses,
Yes, it's already filed.
already filed, but you have filed as a respondent number
7.
7.
Yes.
7 in again Toy Bagra.
Yes, 7 is Toy Bagra.
As per this order, dated 21/5/2025.
The number of other accused. don't
I
try
may
to
be allowed to correct that.
Okay, Divya Tara. File. File. As a respondent number? No, 3 is again Niru Das. It was not the respondent, it was earlier only serial number only. Okay, serial number in what? Can you just pass the serial that the order which contains the serial number? Senlar Ronya. Senlar Ronya. Okay, this is notice only. Not mention the respondent number.
But the information matter, yes.
Senlar Ronya. Okay, so I think then his case was abated probably last season. Okay. Jamlo Tagung. Have you filed? Not yet. And then the respondent number? Not, not assigned. Millie? Filed? No. Not yet. Inamul? Okay. Postpanjali? Okay, and then Michitabin? Michitabin? Who represents Ketari and you have already filed? And then probably there was addition of the offense after filing. Yes. Supplementary, as per the supplementary charge sheet. So, okay, that has been incorporated in your affidavit or objection. You want to incorporate, then you have to.
As per supplemental charges, frame, my lord, Talco.
Okay. So you have filed the objection as a respondent number?
I've not mentioned the respondent, I meant.
Okay.
Name,
Okay, okay. I don't know why they have not mentioned, but then if this respondent number is assigned as per the accused number,
yes,
would have been much better because their accused number of A1, A2, A3, if it coincides. Though yet it is not clear, although I have marked it because in continuation of this 12, 13, 14, 15, 16. So, but at one go, if we can link with the accused number, then it will be better.
Yes.
Because otherwise it will always it will create confusion.
Yes, madam, there was direction for rearrangement of the money.
Yes, rearrangement they have tried, but then all have not been marked. Yes, then that can be continued here also. By which order?
it was,
It's a trial. It is trial court record. Okay, by which order? When the charge was framed?
28/11 of 2024.
28/11.
Yes.
A1 is Bamantaya. Bamantaya here is 11. Could be A1. Okay. We'll continue with this. Okay. Henceforth, Toy Bagra is 2. Saddam Hussein is not here.
Maybe in the second document. That was that is the first one, another certificate.
He probably was not granted bail. Bulang Marik.
A3.
A3 is serial number. Please pass on the this table also. Bulang Marik. Yes, one is A4. Who? Bulang Marik?
Number 1.
Yes, but then this, because and all other will change. We have to change this as per the accused number. We have to coincide with the accused number of it.
But there will be one little
Number, and then accused number would be different.
three orders have been passed by.
Okay, then we'll have
by
to.
completing the rest of it.
Okay. In any case, we'll, just a minute. So, Neelam Manga. Chandler Ronin. A7. Tom Langdi, A8. Ten. Divya Tara. 11. 7. 12. Cecil Sin 13. Among Moses. Fourteen. Nagaram Buru is not there. Okay. Counsel and standing counsel for the petitioner. Yes, Guwahati High Court, Iranagar Permanent Bench. The Pangeng is not present. Okay, Mr. Land Counsel appearing on behalf of Mr. D. Pangeng, Land MRS Curie for the victim. And Mr. Ete. Oh, yes, Ete, Land Edison PP. Stop. Para. For respondent number 2 within bracket A8. Huh? So respondent number 7 within bracket A2. Miss semicolon, Mr. Ensoki. Yeah, you are Miss B. Marde. Your name is also there, Miss B. Okay. Okay. Just wait. Huh? Wait that one. Leave that one. Huh? Mr. Who appears on behalf of Arsona?
Yes.
Okay. Okay, A6. Respondent number 14, A10. And respondent number 14, A10, huh? You are representing Ridonime also?
Yes.
Okay. Semicolon, again. Mr. Who appear on behalf of Bamang Moses? Okay, Mr. D. Saikya. For respondent number 15, within bracket A14. No, Nilam Manga also, leave it for the time being, huh? Ridonime, correct, huh? And Bamang Moses, D. Saikya for respondent number 15, within bracket A14, huh? And Mr. Respondent number 21, within bracket A12. Who submits that they have objection? Start, huh? Para. Mr. And then who was for Puspa Mandal? Yes, Mr. P. Datu, Lane Council, appearing on behalf of accused Puspa Mandal, A10. Not A10, huh? Respondent number 10. And Mr. Respondent number 13, within bracket A6. Praised for, the sum is that although they have filed their objection, however, praised for withdrawal of the same with liberty to file afresh after making necessary correction. Stop the prayer is allowed. Okay. And then next para. Mr. Who for Niru, sorry, J.K. Goswami or who? Ganguly?
Yes, I'm for Dulal, Dipali and Lakshmi Gaur. Dulal Basumatari, Dipali Basumatari and Lakshmi Gaur.
Mr. A. Ganguly, appearing on behalf of accused Dulal Basumatari, within bracket respondent number 4, Dipali Basumatari, within bracket respondent number 5. And who else? Dulal,
And
Dipali, and
Lakshmi Gaur. Lakshmi Gaur.
Lakshmi Gaur, okay. Council appearing on behalf of accused Techi Anya, within bracket respondent number 8. Bamang Taya, accused, sorry, Bamang Taya, within bracket respondent number, no. Then after sending AK Singh, representing accused Rasna Mili, within bracket, respondent number 12. Who else? You represent who else? Just a minute, huh? Mili Jamlo Tagong, with Jamlo Tagong, within bracket, respondent number. Respondent number 17, Jamlo Tagong, within bracket, A5. Purnima Mili, respondent number 18. Emmanuel Haq, respondent number 19. And Puspanjali Mili, respondent number 20. Inverted comma, close. And who else? Then, just a Mr. Just 5 it is. Okay. Mr. Senla Ronya, earlier, I think this should not reflect any.
On the last page of letter 5A, from 35. But inform before this court that he had passed away.
Yes, I remember. So these four, by last order probably, is 5A. Senla Ronya, okay, abated. His name was abated. Okay. So we will not reflect his name any longer. Okay. Because his name has already been abated on his death. Accused name?
Ridonime. For him, I have mentioned number 6. For it, I need some correction.
No, Rido Rime already filed. Didn't I mention?
This morning I have filed, but
This more, but didn't I mention in my order today? Mention. I think already mentioned. Neelam Manga, you wanted to correction. That was also mentioned. And Rido Rime, did I mention or not?
For correction, it is not mentioned.
Rido Rima also?
Yes,
Also. Okay, then in that case, Mr. What was your Pushpa Mandal of Pichato, Land Council appearing on behalf of accused Pushpa Mandal, within bracket, respondent number 10. Inverted comma. Earlier dictated, you just correct it, huh? Mr. M. Kambo appearing on behalf of accused Neelam Manga, within bracket, respondent. Mr. Kambo on behalf of accused Neelam Manga, respondent number 13, within bracket A6. And Mr. Rido Nime also already filed. You want to correct that one also? Okay. And Mr. Rido, Rido is Mr. or,
Mr.
Okay. And accused Rido Nime, respondent, respondent number 14, within bracket A10. That. Submit that, although they have filed that. Okay. Prayer allowed. It was allowed only. Okay. Nivedara is respondent number 16. And then he is A11. You did not say that. Oh, yes, already filed. Yes, you have already said filed. Recorded, already recorded. What do you want? We cannot allow by hand. Oh, that, okay. Okay, in that, Divya, para one line, Mr. R. Koyu, Lana Council appearing on behalf of accused Divya Tara with, respondent, within bracket, respondent number 16, within, respondent number 16, huh? No, comma or respondent number 16 within bracket A11 submits that, in his objection, the accused has been, in his objection, the accused is filed as the respondent number 3. Therefore, he prays, and since this court has renumbered him as respondent number 16, he may be allowed to correct the correct the same from respondent number 3 to 16. Only in the probably, or in all the in the body of the objection also you have mentioned the respondent number, or only in the cause title? Okay.
Milord, in our case, then respondent number 13 and 14, there we have mentioned in the body also in objection.
No, that is why you are withdrawing that. Your respondent number?
Respondent number 13 and 14, that
13 and 14.
Kambo sir was mentioning.
You are withdrawing that with liberty. Now you have your respondent number. Okay. So anyone? Okay. This, the prayer is allowed. Huh? The respondent, the prayer is allowed. The respondent is allowed to correct with whom we need, with register, or who generally used to do in the registry? With the permission of the registrar judicial. Okay. Okay.
Lordship, yeah, in my case also, in case of Bamang Moses, I have also responded.
Okay, then
Similar order.
only, okay. Then Mr. R. Koyu and Mr.
Complete the matter, madam. Parties are directed to the character that the respondent.
Okay, then in that case, any other respondent also need to correct. Then in that case, we can pass general order. Okay, then say Mr. Saikia, Land Council appearing on behalf of Mr. On behalf of
14.
14 is
Respondent 15.
Respondent 15 is Bamang Moses. Okay, Land Council appearing on behalf of accused Bamang Moses and his name, Mr. Koyu. For Koyu is for accused Divya Tara. Submits that in view of the renumbering of the respondent, they may be allowed to correct the same. Okay, the prayer is allowed. Then the registry shall do the needful. Okay. Okay. Anyone missed out? No. I think now it should be settled next time.
In my
Okay.
case, I have not mentioned the numbers by name.
Okay. Then his name also in the same. K. Tari appearing on behalf of accused Michicho Tabin. Okay. Thereafter, then did I say prayer allowed? Okay, the prayer allowed, huh? Okay, list this matter. When, how much time How much time would be required to file objection? 3 weeks, okay. List is matter after 3 weeks, stop, huh? Since the name of the respondents has been corrected and accused name, number has also been inserted, comma, the registry shall prepare. The registry is directed to prepare fresh table showing the name of the accused, showing the number of the accused, sorry, just showing the serial number of the accused, name of the accused, comma, name of the accused, respondent, and their accused number given by the trial court, and their advocate, and the name of the advocates, and furnish the same to furnish a copy of the same to all the counsel appearing on behalf of the respondents. Okay. Now automatically it must that the serial number now will be exponent number. Okay. And then in the accused name, only the accused name that will be subsequently added after just a minute. It appears that charge was framed only against 15. 22. Where are the rest? Rest is also here. Okay, next page. Next page I didn't see. Then in that case, the others are also accused now. Techi Anya. Techi Anya is what is the serial number? Techi Anya. Who represents Techi Anya? Okay, and then respondent number 8. Okay, Techi Anya within bracket, huh? A16 against Techi Anya. Okay, within bracket A16. And Puspanjali Mili would be A17, huh? Mark A17. Again, Purnima Mili would be A18. And Rasna Mili is A. Rasna Mili, who, yes, 18, A18. Sorry, 19, sorry, 19, A19. Once this is settled, it will be, there will be no problem. Dulal Basumatari is where is Dulal Basumatari? Yes, A20. A20. Huh? Inamul Haq would be Inamul Haq A21. Dulal Basumatari was respondent number 4. Huh? Inamul Haq is 21. That is respondent number 19. Huh? That is A21. And Dipali Basumatari A5 is, sorry, respondent number 5 is A22. and Lakshmi Gaur. Respondent number 6 is A23. Puspa Mandal. Puspa Mandal A. Yes, A10 is 8. Sorry, respondent number 10 is A24. A24. And Niru Das, respondent number 3 is A25. And Deepak Parajuli. Where is
Deepak Parajuli, in respect of Deepak Parajuli, he has not received any notice till date.
Not yet. Okay. But he was granted bail. Deepak
Yes, he was
Parajuli.
granted bail.
Deepak Parajuli has not yet been impleaded.
No, no.
Mr. Ganguly, not yet been impleaded.
No, no, no. No, Your Lordship. He has not received summon till date.
Oh.
All are on bail.
Okay. This Deepak Parajuli is respondent number. Deepak Parajuli also. Then have one small paragraph. Then it PP submitted. The accused Deepak Parajuli was also granted bail. He may also be issued notice. Stop. Issue notice. Accordingly. Mr. Ganguly, are you representing Deepak Parajuli also?
Yes, yes. I'm before the trial court. I'm representing him, and there is another accused. One of my accused, another accused, Nandaram Boro. He has also till date not received any summon or notice issued by this honorable court.
Gangaram, I think Gangaram was not.
Nandaram Boro. Nandaram.
Okay. Whether charge was framed against him also?
Yes, yes, yes. Charge has been framed.
Charge framed. His name is not there.
Yes. Lordship.
What is his name?
Nandaram Boro.
Nadram. Oh, Nadram.
Boro.
It's Nadram. Nadram Boro.
Nandaram Boro.
It is written Nadram only, not Nandaram. (22) within bracket A15 and Deepak Paranjuli, respondent number 23 within bracket A9 are also being represented by Mr. A. Ganguly. However, Lana PP submits that notice, Lana PP first. Mr. Nandaram Boroha and Deepak Parajali were also granted bail. Therefore, they may also be issued notice. Then after that, this Ganguly, Mr. Ganguly. Nadaram Boro, respondent number 22, na? A15, huh? And Deepak Parajale, respondent number 23, huh? He is A9. Mr. Ganguly represents, huh? And okay. Issue notice these two, okay? All good, huh? Comma, as prayed for, comma, list is, as prayed for, list is matter after 3 weeks. Okay, yes, anything?
What I'm doing is that all the affidavit is to be filed on 22nd October and final hearing may be fixed on 24th.
22nd?
22nd October for filing of affidavit and 24 may be fixed for final argument.
Okay. Then, the respondents are granted. Just me. Eighth grade for comma, list is matter on 24. The respondents are directed to file their respective objection of affidavit on or before 22 October.
Well, yeah.
Okay?
Yeah.
Obliged, Your Lordship.
Item number 16.
Have you filed affidavit? Of
I beg some more time for this justice service. I'm appearing on behalf of the Homo.
you for the
Yes, I'm
okay.
on behalf of.
That's the already served.
No,
Not yet closed.
yes, we need some more time for justice to be completed. So,
Okay. So not yet step not yet taken. Okay. You are Mr.
hey, government,
Learning Counsel for the petitioner.
on behalf of the Homo.
Learning Counsel appearing on behalf of Mr.
The Homo.
Homo. Learning Counsel for the petitioner. Praise for father. How much time? 2 weeks time.
3 weeks.
Father 3 weeks time to take steps upon the respondent number 1 to 5. By the service and to file affidavit. The prayer is allowed. List is matter, but prayer is allowed. 3 weeks time, huh? Okay. So the petitioner is granted further 3 weeks time to take steps upon the respondent number 1 to 5 by way of justice service and to file affidavit to that effect. Okay.
Item number 17. Item number 17 and 18 are analogous method.
Analogous matter.
We were ordered to take steps in this matter, but we have taken the step, but upon looking at the records, it is yet to be complete.
No, in 17 you have not yet taken steps. You have taken steps in 17.
17, yes, Lordship.
Service is. Okay, 17, you have taken steps.
It's yet to be completed.
Okay, Mr. Okay,
And-
Mr.
Lordship,
You are Mr.
A. Gamre,
Land Council for the applicant is present. The office note dated 12/9/2025 reflect that the service report
Lordship,
sole respondent.
yes,
Service upon the respondent, service upon the sole respondent is still awaited. In view of the above, this matter of week,
2 weeks, Lordship.
2 weeks. Okay, 2 weeks. Then item 18.
It's analogous method
18 is analogous with which
with
one?
17.
17.
Yes, Lord.
Okay, same.
Lordship,
Here also awaited.
yes.
Okay, similar order, huh?
Lordship, I'd like to bring into your Lordship notice that in this matter, even during the trial of this matter, the respondent not once appeared. And as such, I pray that your Lordship may kindly allow to take steps by concerned TS.
Which one? Item 18.
Both, the respondent in both 17 and 18 are the same.
Okay, you want to take fresh steps?
The judicial process is underway, and upon that, we want to take steps from concerned TS also.
Okay, then in that case, right, Mr. So and so, huh? Submit, just a minute. Okay, in view of the, don't, I cut the other one. In view of the, of this note dated 12/9/2025, Mr. So and so, what was your good name? A.
Gamre,
Gamre.
yes.
Gamre. Then counsel for the applicant, praise for allowing him to take fresh steps upon. What is this? This is for what? Criminal?
Yes, criminal appeal.
Hmm? So the concerned police station. The prayer is allowed. Steps upon the respondent by a minute now to be taken. So it is through concerned police station means it has to go through.
Site,
Okay.
OC.
Propose service upon the sole respondent. So the concern OC police OC. It has to be. Criminal appeal. Can it go through police, concerned police station?
Yes, Your
Or
Lordship.
OC?
To the OC,
Through-
Your Lordship. But then it won't be,
It will has to go through PP.
no, since this is a private complaint case,
You who will serve? respondent. What do you want now?
Lordship, first step.
It was way. Now press steps by way of what case? CRP. Register post. Okay, in view of the office note dated 12/9/2025, Mr.
Emma.
Land Council for the petitioner praise for allowing him to take fresh steps upon the respondent number 2. The prayer is allowed. Stop para steps upon the respondent number 2 by a registered post with 80 as well as by usual process within a week from today. So, please this matter after 3 weeks. Okay. Then our present may also be recorded. Okay.
Okay.
Item number 20.
Yes. Service awaited.
Your Lordship, I am for the private respondent number 2.
Okay.
Your Lordship,
You are okay. Respondent number 2 to put it
yes.
here.
Yes, please.
How many respondents are there?
2, Your Lordship.
Only 2.
Yes.
State is 1.
One is ADC Kamba, Your Lordship.
ADC Kamba. 1 is state. State represent. Okay. Mr. You are Mr.
M Taso Mindo Taso. Your
Planning
Lordship.
Council for the petitioner is present. Stop. Miss
P. Lomdak.
P. Lombe. Lomda.
Yes, Your Lordship.
Okay. Planning Council put appear on behalf of the respondent number 2. It's a criminal petition. You want to file? You want to file objection?
Yeah. I may be given some more time to file.
And pray for allowing us some time to file objection. The prayer is allowed. List this matter after. How much time you require?
3 weeks, Your Lordship.
3 weeks. Okay, then.
Your Lordship, there's in or stay order.
Okay, Jeannie's present may also be recorded. Huh? Okay. And then list this matter after 3 weeks. Huh? The interim order passed earlier shall continue till the next date of this week.
Right, there was a direction for calling of the CD.
CD,
We have not received this. Some miscommunication.
it's a criminal petition or case that was called for here.
Has not been calculated.
Your Lordship, there is a title suit going on in Alo civil.
Title suit.
Lordship.
Is it connected with this civil case?
Yes, this
So
is
this is a criminal petition.
yes, Your Lordship. This is regarding quashing of an FIR, Your Lordship.
Okay,
Regarding
but
the same
how title
matter.
suit is- How title suit is connected?
Your Lordship, this is a civil dispute which has been turned into a criminal matter, Your Lordship, by filing FIR.
So what do you want to say?
Your Lordship, let respondent come with objection, Your Lordship. Let respondent come with objection, Your Lordship.
Re-
Come with objection, Your Lordship. Yeah.
They will file objection.
Yes, Your Lordship.
Yes. Record was called for in the,
The CD was called for Your Lordship. Since the matter has not been calculated, Your Lordship.
okay.
Still under investigation. If I may, Your Lordship,
By which order it was called for?
on 4.
4/6. Okay. Okay. Miss Jeannie Lane additional PT. Notice was issued, but then where the record was called for? Accept the notice. record was called for? I don't see.
On 4/6, your lordship will find the last, that's one.
Okay, on the next date, okay, PP, list, scan copy, okay. Let's be present, huh? The scan copy of the case diary is still awaited. The registry to be directed?
No, I may be directed to lordship.
Okay, Miss Ginny shall produce the scan copy of the case diary on the next date, okay? Could we fix the date
After vacation on.
after vacation?
Since they are seeking for 3 weeks time. I may-
Okay, automatically. Okay, okay, least this matter after 3 weeks, no? On which date, Mr. Miss Jenny shall also produce the updated case diary, okay?
Quickly obliged.
Item number 21.
Lordship, I'm extremely sorry. In item number 19, there is an interim order. That may be confirmed.
Okay. 19 here. Of the interim order, pass are this comes until the next date of. Yes. This is what, this is one petition. Yes. What is this case about?
This is matter mutual criminal petition for the
Okay, then you
settlement.
can list it for
Yes, ma'am, for the admission matter,
admission.
my lord.
Okay. Mr. Saikya, Land Council for the petitioner, as well as Mr. Portal, Plan and Special PP, SIT are present. The scan, see, this is the scan copy,
Yes, my lord.
scan copy of the trial court record or CD,
Record, ma'am.
trial court record, I can receive. List is matter. Next week for admission. After preservation. Okay. After puja vacation. Okay.
Obliged.
Item number 22.
Scan copy only, no need to return.
Yes, ma'am.
Okay.
Item number 22.
Then the A is prayed for, huh? Come on, this is matter after the entering puja vacation. Okay. Yes. Yes.
This matter is lordship, NIX, negotiable check bounce case.
Okay.
In this case, lordship, I'm aggrieved by the interim compensation under 145A of NIX. So matter is, as per the record, matter is back out. But this 145A is a directory in it. This is a just while passing the concern, while passing the order, this, here is a guideline, FX code guideline that that has not been followed. Because before issuing just interim compensation, the court has to look into it. I have submitted the already copy on the last occasion.
What copy? Now, there is or are how many respondents?
Your lordship,
Some private also there.
private, only one respondent and the service is awaited, your lordship. Also, on the
Respondent
initial,
number 2,
true, your lordship,
still awaited.
still awaited, your lordship.
Have you served copy?
I have
Still awaited when it was? July. What do we do? You want to take fresh steps or what?
25.
Hmm?
25.
You know,
This matter is going on and the judicial magistrate first class is compelling me to.
wait, which judicial magistrate of which district?
Judicial
UPR.
magistrate first class. This magistrate.
And then where do these respondents stay?
She stays in Nahalagan itself, Your Lordship. Your Lordship, if I may, Your Lordship, on the first date when the matter came up, Your Lordship, the matter was heard at length, and there is an order stating that the interim will be considered on the, after listening to the private respondent, Your Lordship.
Okay, private respondent never
Yes.
appeared.
No, they
Since
have,
then.
the service is still awaited, Your Lordship.
Hmm.
If I may, Your Lordship, suggest that if that is the situation till date, Your Lordship, they may take steps through the office of the PP, Your Lordship,
Take a step, fresh steps in that case.
because the matter is pending since only for,
Let us wait for next.
It will not serve any purpose. After vacation, you want to without a step. Why? Step one, steps, it will not take much. You take better if you are interested in the case. It's always better to take fresh steps. Awaiting, because since June, it will not come back now.
It is
Somewhere it has been misplaced. And since June, before transfer, probably may have also been misplaced somewhere.
yes.
You take fresh step better. Mr. In view of the office note dated 12/9/2025, Mr. Tapa, Land Council for the petitioner, praised for allowing him to take fresh steps upon the respondent number 2. They are allowed. Steps upon the respondent number 2 by a registrar post with AD as well as by usual process within a week from today. So, list this matter after 3 weeks.
After 3 weeks.
Right. That is all automatically after vacation.
Yes. Your Lordship, if I may pray, Your Lordship, since there is no interim, the updated TCR may be called for.
Okay. And on which date? No need to fix date.
On 22/10, Your Lordship, otherwise.
22/10. Okay. Let's pray for some matter again on 22/10. On which date? Next daily done additional PP.
Your Lordship, registry, Your Lordship.
Hmm?
Registry may be
Okay.
directed.
Okay, then in that case, it is on 22, huh? In the meantime, the registry is directed to requisition the updated case
Yes,
diary.
no, updated TCR, Your Lordship.
This is TCR?
Yes, Your Lordship.
Okay. Then in that case, what is the progress there?
Because since there was no interim, Your Lordship.
Again, a judgment or what?
This is against an order where he had been directed to pay, since it's
Interlocutory order. Interlocutory order. Okay, updated trial court as well.
DPO.
Item number 23.
Mayor, Your Lordship.
Yes.
Your Lordship, on 08/01/2024, two subsequent.
You are ready for hearing?
Yes.
Okay, you are also ready?
Yeah.
You are for private respondent?
No, for the government respondent.
Hmm?
Government respondent. yeah.
Government, this is a second appeal.
Yes.
How many respondents are there?
Respondent. yeah.
5 respondents.
You are representing all the respondents?
Yes, sure.
Okay.
By order dated 08/01/2024.
Just a minute, huh?
Yes.
Just a minute, huh?
Yes.
This second appeal against?
Against title suit number 20/2016.
Passed by?
Passed by Alo.
Hello?
Yes, CGM Court Alo. Then it was appealed at ADJ Basar, second appeal. The appeal was done at ADJ Basar.
Okay.
And then we are for here.
The appellate court, what order was passed?
Affirm the
Order passed by the
original court.
senior division.
Yes.
Yes, now we can start.
Yes. On 08/01/2024,
two substantial question of law was put by this court.
No, yeah, by this court.
Yes. Number one was whether the title suit filed by the plaintiff appellant is
Date order dated
08/01/2024.
24.
Yes.
Zero one,
08/01.
0801.
Yes. January 2020.
Yes, yes.
Yes.
The trial court record, original trial court record has been received.
Yes, Your Lordship.
Because this court, in the earlier occasion, since it was only scanned copy. This is original. Okay.
Yes. Yes. Your Lordship, two substantial question of law was formulated, basing on which we have to advance our argument. Number one is, Your Lordship, basically, if we address the number one point, the rest, number two, determination will not be that much. Your Lordship, whether the title suit filed by the plaintiff appellant is barred by the law of limitation, estoppel, acquiescence, or waiver. With this regard, Your Lordship, may I take Your Lordship to annexure number 8.
See, first of all, let us read the judgment.
Yes, it's page number.
Judgment of the trial court,
Yes, it's
not the appellate court.
page number 42.
Page 42.
Yes, annexure 8. This is judgment.
Yes, this is title suit judgment, and the decree is in page number 52. It is judgment is from page number 42.
Okay.
Yes. Basically, Your Lordship, since this is a long judgment, to cut it short, my title suit as dismissed, citing that it is bare by the law of limitation, under law of limitation. Since I have the year for the agreement was done in the year 1977, I had come for the title suit in the year 2015. So counting it almost comes up to 40 years.
Yeah, what was the agreement?
Agreement was with regards to a plot of ancestral land, which 3,780 square meters of land.
You inherited?
Yes, it was my ancestral land. Then basing on the request of the government at that time through political interpreters, I had conditionally with agreement, I had donated it to the respondent. Respondent number two, respondent number.
In which year?
In 1977.
There is a document?
Yes, there is documents. May I take Your Lordship to page number 30. '31 is the type copy.
What agreement we call it?
Page number 30.
30 is?
Yes, 30 is the agreement.
First agreement?
Yes, first agreement. The sole agreement basing on which they are occupying my land.
So this is the land donated for what purpose?
This was donated for establishing PWD office at Turbin.
This is who has received the land?
Respondent number. Basically, it was received by respondent number 3.
Which one is respondent number 3?
EAC Turbin.
Which one?
Respondent number 3. In this agreement,
where is his name reflected?
His name is not there. On behalf of him, the political interpreter at those time.
Which one is political interpreter?
This Karsen Riba, Tommy Wasar, Nyapak Lombe. They acted on behalf of him. This was the basic contention, your Lordship. At the title suit, my land has not been annexed as per the Land Acquisition Act. I had put all those pleadings at the title suit, but with
No, just a minute. So this, according to you, it was not received by anyone, but you have donated.
yes, according to me,
What is the observation of the Line Trial Court regarding this document, whether this was admitted as a genuine?
yes, this was admitted as genuine, but basing on 1977, they are saying that these documents. However, since you have donated way back in 1977, now at 2015, you cannot come for title suit because law limitation barred. Only this is the point, Your Lordship, which we have to determine here.
No. Where do we find that this document was treated or admitted?
Your
Because
Lordship,
this document itself doesn't look
yes, that was
genuine. Where it says in the judgment or anywhere
yes.
that this document was admitted. Document was admitted.
Your Lordship, page number 46, Your Lordship. Judgment of the trial court, Your Lordship.
Yeah.
Paragraph number 10, Your Lordship. May I, Your Lordship?
Yes.
From below to the 7th sentence, Your Lordship. I have found that Your Lordship has got it.
There is no signature of the government official.
Neither any undertaking was executed by the government of Arunachal Pradesh providing facilities to the plaintiff, Your Lordship. It was the observation
It was
of
not
the
admitted.
trial court, Your Lordship.
It's in exhibition, Your Lordship, in page number 51 in the judgment portion.
In the appreciation. Yes, the appreciation regarding the document. It was not admitted on the. The plaintiff has no right for claiming that the land from the government of Arunachal Pradesh or any other department, including the public work department. There is no cause of action for filing present suit. So you came almost around after 40 years, 39 years.
Yes.
Say 40 years.
Yes. Your Lordship, with regard to the veracity of that case, order was issued from the learned Chief Judicial directing the extra assistant commissioner Tirbin to ascertain whether he had really donated that land or not. That order was issued, and accordingly, while the trial was proceeding, the learned the respondent number 3 had filed a deposition, which is in annexure number 38.
What is the next 38?
It's to ascertain whether the plaintiff had really donated the land or not, and also to ascertain the annexure number 3, the agreement. The order was passed directing the EAC, which is respondent number 3, to ascertain whether he has really donated the land or not. Accordingly, the
Where
EAC.
is that order?
Its order is not there. However, I have annexed the deposition filed by the respondent number 3 EAC, page number 38.
Inquiry report.
Yes, inquiry report. inquiry report, page number 41, the conclusion part.
Yes, let us read
Yes,
the entire inquiry report.
yes. May I read your lordship?
Yes,
Submission of inquiry report. I'll start with page
come directly to 39.
39, inquiry report. After having gone through the order number such and such, the 20/2016 on dated such and such passed by the Honorable Chief Judicial Magistrate cum Civil Judge Senior Division Weshang Alo in the title suit case between Sri Yorkop Gade versus Secretary PWD and others, the following issues has been instructed to be inquired into under the fact. Number one, whether the copy of bill loss assessment report pertaining to valuable plants and trees now being claimed for compensation is the actual copy submitted to the Circle Officer Tribune on 2 occasions, vice 1977 and 1982. What is the actual area allegedly encroached upon and under illegal occupation of Sri Budam Gade, son of late Larbu Yorbu Gade? Further, whether the area under the occupation of Sri Budam Gade is going to be allotted to him or her, him regularized or not. Findings. Issue number one, the deposition of following elderly people, senior citizens who were mature enough in 1977 and 1982 are reproduced below. Number one, Sri Buddha Gade, retired Deputy Commissioner, 62 years approx. People were asked to clear the land where trees and other valuable horticulture trees were standing to facilitate establishment of various government departments. Once I wrote a letter to government to establish a hospital in the land of Sri Yorkop Gade. Undoubtedly, there were lots of horticulture trees like orange, guava, pears, and trees in his garden. Number two, Sri Tayuta sir, Chairperson 7, Tirbin Anchal Samiti, 65 years approx. Not only Yorkop Gade, but also all the residents of present Tirbin Circle headquarters were asked to vacate their land to pave way for construction of various structure. We were assured of paying compensation for the horticulture trees and other valuable immovable properties. No compensation for the land was assured. The pile containing the loss assessment report bill had been lost from the circle officer's office. Sri Kagjar Gade, in spite of assurance given to the landowners to compensate for their horticulture plants and other immovable property, no compensation has so far been paid to any person. This is the reason why people have started claiming back their land. Sri Taka Gade PI, public interpreter, about 58 years, and Sri Taka Lombu, 57 years, but may around 70 years. We are unable to record the exact number of horticulture plants and trees, other valuable trees, but for sure there were many. Sri Yorkop Gade is not the only victim. There were initially about 15 families residing then at Tirbin, and all have been the victims. We were assured of commercial as well as residential plots in lieu of the land that we had to part with. Further, we were also promised to compensate horticultural garden in monetary terms, but the file got lost somewhere. It is very difficult to consider exactly the file got lost. The men who came to Tirbin and persuaded us to vacate the land and property were Sri Karsen Riba, political Jamedar, who was very powerful at that point of time, Sri Tomi Basar, PI, Sri Nyapak Lombu, PI. They were sent by the government of Arunachal Pradesh to acquire land for the purpose of establishment of headquarters at Tirbin officially. The administrative center was established in 1975. From the above interaction and discussion, it is very difficult to draw conclusion if the loss assessment bill being claimed now is same copy which was sent to the COA back in 1977 and 1982. The original bill copy is completely lost now and no one has ever come across it anywhere. However, it can be said that government had assured to compensate the lost property and had assessment thereof. Also, it can be concluded that some 15 families had lost their immovable property while shifting to another place to pave way for the establishment of administrative center. Issue number two, the total area of land allegedly under the illegal possession of Sri Budam Gadi, son of Sri Yorbu Gadi, is 250 square meter approx. As per records available in the office of the Extra Commissioner, Tirbin Sri Budam Gadi has not allotment. Conclusion, I am inclined to conclude that although the compensation bill being claimed by Sri Yorkov Gadi may not be the true copy of original bills prepared by the government, yet it has been proved beyond reasonable doubt that he had a horticultural garden with fruit-bearing plants and other valuable trees, and they had been cut down, uprooted to facilitate establishment of administrative center. The land allegedly under the illegal occupation of Sri Budam Gadi is 250 to 300 square meters and is not being processed for allotment, regularization in his name, but it has been under his occupation for the last many years, and he make allotment in days to come.
This 250 to 300 square meter. Yes. This is where? In the same place or?
Yes, it's come under same 3,780 square meter. Basically, Your Lordship, in my title suit, since my donation was based on two conditions. Number one was for allotment of separate plot of land along with license, liquor license, and number two was for compensation.
77. What condition is this in the year 77?
I think, Your Lordship, in the year 1990 or some, the liquor
came-
permission was granted in the state of
No,
Gujarat.
it was shop license with plot of land for shopping purpose, maybe immediately be
Shop
sanctioned.
license was also not required 77.
I think so, Your Lordship.
Yeah, Your Lordship,
77, there was no soap. There was hardly soap.
yes, this is the problem, Your Lordship. Basing on these documents, the respondent now they have set up office there. The horticultural garden. Now I say,
See, that is
yes,
maybe your land, but then this document,
yes,
the condition contained in the document in the year 1977, when
Yes.
there was no soap,
yes,
liquor soap was never imagined.
yes,
There was no soap. Whosoever wanted to open soap,
yes,
it was only non-tribal
yes,
coming from outside,
yes.
maybe few soaps. And in the Tribune, I don't know. In Alo, it will be, of course, 77, it will be present, Alo Pasigat. And in the main headquarters, but Tribune, probably hardly soap.
Yes.
It's a Tribune. In
Uh,
Tribune.
Yes, it's Tirbin. Now it's ADC headquarters now.
ADC
Yeah.
headquarters. Now also, I think it should not be much big, that big.
No, Your Lordship, it's big now. Your Lordship, the main point here for us to determine is whether the trial court had rightly rejected my title suit, saying that it is barred by the law of limitation. Only that is settled, Your Lordship. The matter can be reverted back,
Okay.
and accordingly we can argue there
Okay.
with the
So,
bearer.
okay, then. Okay, this is. So, because in order to a certain date also, because that rejection also considering
Yes,
the entire matter,
yes,
whether if you have a right,
yes,
then the limitation comes.
yes,
If you have no right at all,
yes.
that also will be difficult to consider regarding limitation also.
With that regard, Your Lordship, it was for them to come and file the deposition. I am saying that you are illegally occupying my land, but they have not filed it. They have not, in the entirety of the trial, they have not even appeared.
In the condemnation petition, whether they file objection,
Condemnation with regard to this,
for
RS.
filing title suit,
yes,
court must have asked you that you are, there is a limitation bar. Have you filed condemnation petition there?
no, it was the entire trial proceeding was admitted during the time of when Tage Hale sir was presiding, and he had in fact ordered for this inquiry report also, and he has admitted some witnesses also statements. But meanwhile, he was transferred, and Justice Harendra Kesab sir, he came and he had passed this order. no question of whether there was a delay or not. That was not, issue was not raised there.
Okay, this is then, this is the inquiry report. So these, it must be available in the, what? Or what led the court to order for inquiry report. This inquiry, order was made when?
This was 03/02/17 on
So while passing an order for directing for inquiry and submission of report, this question was not there.
not
The
there.
question of limitation.
No, not there. Rightly or wrong,
When it was admitted?
it was my title suit was filed in the year 2016.
16.
Yes, and this order was
Pass on.
inquiry order was passed on 2007.
17 date.
That 03/02/2017.
Okay, 03/02.
2017. Yes. Already my case was admitted.
Then two or no order on 0. Okay.
So basically,
Okay. Your application was admitted on 2016. You filed on 2016.
yes.
Okay. Thereafter, it was transferred to civil judge. Hello.
Yes.
Which department you said?
PWD department.
Only PWD.
Yes.
He was proceeded expert or what?
Yes, Your Lordship, it was proceeded ex parte.
Despite of receipt of notice, you did not contest
Yes, Your Lordship, as per the judgment, Your Lordship.
as per the judgment. Judgment also ex parte.
Yes, Your Lordship.
However, in between, filed one deposition.
No, without contesting how deposition.
No, they have filed. It's in the record.
No WS.
It's in. I have annexed it in page number 7.
Whether they have filed, whether they contested the case.
Yes, At one point of time, they contested, they filed the
While
petition.
contesting, have they filed affidavit or next, written statement?
Yes, they have filed one. They have filed one deposition saying
No statement.
this is.
But
May I read
that
your
will be
lordship?
written statement only. Thereafter only the petition is filed.
No, they have filed one. May I read your lordship? Actually, whole TCR is not with me. However, this is your lordship. May I read? To the Chief Judicial Magistrate, come Civil Division, Senior
That is not a
Division.
deposition.
Yes, with reference to above, following points are brought to your kind notice as under, please. As per out of 3,700 square meter of land in government, only they have admitted, respondent have admitted that out of that donation, 2,150 square meter is stated to be used by the PWD. They're admitting out of 2,115, a portion of land is under illegal occupation of Sri Budam Gadu, son of Sri Yorbu Gadu, a kith and kin of
Who
Sri
donated Yorba?
Yorkop donated. And they are alleging that
After Yorkop?
after Yorkop, they are alleging that Budam Gadu, son of Yorbu Gadu, is occupying 250 square meter of land.
Who is Yorba Gade?
Yorbu Gadu is another person, your lord.
Okay, not Yorkop.
No, not Yorkop.
Okay, not the son of Yorkop.
Not son of Yorkop. I think him. They are alleging they are while submitting.
Okay, you are also not connected with Yorba.
Yes, yes.
You are otherwise in descendant of Yorkop.
No, I am descendant of, yes, Yorkop. This is Yorbu Gadu, Budam Gadu. 250 is occupied by Budam Gadu, who is son of Yorkop, Yorbu Gadu, and I am Yorkop Gadu. And may I read the relevant one, your lordship? As per serial number 2 of donation letter dated 0703-1977, Sri Yorkop Gadu has been awarded contract work amounting to rupees 3,19,404.
When?
In the year 2015.
Okay.
This is the point why I'm
Yorkop was still alive at that time.
Yes, he was still alive.
The person who donated
Yes.
the land.
Yes, that is why I am saying that they had admitted the agreement 1977, and while fulfilling the condition number 2, they had awarded me contract work in the year 2015, meaning thereby the agreement was continuing. And in serial number 1, they were supposed to give me land allotment. Instead, as I have made all my ancestral horticultural land for the establishment, but they could not give me the alternate land. That's why on that day, the course of action will be calculated from year 2015, not from 1977. This is all the point. And as per Limitation Act also, your lordship, there is a provision. Only point that we have to determine, your lordship, is
the foundation for determining that or to knowing that is
Yes.
the case itself.
yes.
So that is why I'm trying to know the case itself
Yes.
first.
All the trial has never been trial. All the proceeding, there has been erroneous application of judicious mind also during the trial. That is why we are here, your lordship. And the main ground in second appeal can be if there has been a non-consideration of relevant evidence and erroneous application of law, then it can be reverted back, your lordship. For fair trial, since I have lost so much of my ancestral
Wait a minute. He has found out the two, defect or lacuna of this. The inquiry was not passed on to, it was 10-2, I think. Yoruba you are not connected with Yoruba.
Yes.
It has a temporary structure.
Yes.
And then this Bidam,
Bidambolo is son of Yoruba.
Yoruba.
Yes.
So this Bidam and Yoruba is not connected to you.
Yes.
They are the encroacher only.
Yes, they are.
The land of the government donated by you.
Yes.
They are the encroacher.
Yes.
And but you are not connected with.
Yes.
So your title suit is basically claiming compensation.
Compensation, yes, Your Lordship, compensation, and I'm saying that compensation and plot land, since all of my land has
As
been
per the
donated.
agreement.
Yes, as per the agreement.
But agreement was not signed by the government.
Yes,
It was only one side,
yes.
one party signature only.
At those time in year 1977, basically the practice was that they used to send political interpreters who acted on behalf of the government, since they were appointed by the deputy commissioner under AFR. So we can.
No, it was not political. 77, EAC, CEO, ADC, ADC, DC, and then that was 77, it was ADC headquarter, or CO headquarter.
Yes, it was CO headquarters.
Then cannot send CO head.
But the respondent has admitted, Your Lordship, in their.
Not under the complete process. So inquiry, after inquiry report submitted, then
Yes, after
Hmm.
inquiry,
submitted, then
Yes.
what order was passed?
uh, thereafter straightway this title suit judgment was pronounced here.
Okay, so let us see the judgment then.
Yes. Page number 42.
There is an order for ex parte proceeding also.
It's in page number 45. In the present case, the defendant has not filed any statement, hence no issue can be framed for determination of the case. However, in the present case, following points for determination of frame by the court for efficiently deciding claims.
Where are you reading?
It's page number 45.
Okay, just a minute.
Yes, page number 45.
That is what was filed 2016. Page 45.
Yes. This is
Yes, it starts from 42.
42. Yes.
Okay, yes,
Yes.
yes, please.
From the judgment portion, your page 43. Page 43.
Yes.
Yes. The present title suit is filed by the plaintiff Sri Yorkov Gade claiming for the declaration that
Yerko is son of the
Yorkov is me.
who's terminated?
Yorkov Gade.
Oh, Yerkov.
Yes, it's the father. I am the son now. Koppaga.
Father was still alive.
Yes, father was contesting this title suit.
Okay, father himself.
Yes. And meanwhile, while the
What is his age?
father's age must be 65 years by then.
So at the time of donation, he was
Most probably he must be 30 years.
20.
30 years.
No.
It was filed in say
2015.
15. 25 to 30 years.
No, he was 20 years.
Yes.
At the time of filing this title suit, he was
65 years.
Where do we find his?
It's in the judgment portion on your lordship, page number 42. Title suit number 20 oblique Yorkov Gade, aged about 65 years.
Okay, then minus 40 would be 25 years.
Yes.
Oh, no, 65 minus 40.
Yes, it's
Yes.
25.
He would be 25 years.
Yes.
Yes, come.
Now, judgment portion, your lordship. The present title suit is filed by plaintiff Sri Yorkov Gade claiming for the declaration that total 3,780 square meters land occupied by the dependent number is illegal and unauthorized. The land measuring 2,155 square meter used land by the dependent should be compensated, and measuring 1,625 square meter of unused land should be returned back to the plaintiff along with competition for the valuable trees in terms of compensation for the valuation trees in terms of money. Earlier, the present suit was filed before the Court of Appeal and Session Judge at Basar. The suit registered as title number 01/2016. Thereafter, the suit was transferred to this court for trial, as the present court is the original court having jurisdiction for trial of the present suit, and the same is renumbered as title number 20/2016. The plaintiff has taken registered step upon dependents, but dependent have failed to submit a written statement in the present case within 90 days as provided under the law. Accordingly, the present suit proceeded ex parte against the dependents. During the plaintiff has examined as many as 3 witnesses in support of the claim of plaintiff. Plaintiff has also exhibited 5 numbers of comments in support of the claim. I have learned that counsel Mr. Tinima appearing on behalf of the plaintiff. The case of the plaintiff is that plaintiff was having an ancestral property at Tribune area in district of Wesiang, measuring 3,708 square meters at the heart of Tribune Circle. The said land was donated to the government of Arunachal Pradesh. And this land is used by the assistant engineer PWD, Public Works Department, was being cultivated by the plaintiff and planted horticultures like bamboos, lemons, palms, ears, guavas, such and such. In the year 1977, the government of Arunachal Pradesh, particularly the Deputy Commissioner, West Siang District, had asked and requested the plaintiff to donate said land for the establishment of government infrastructure. The plaintiff agreed upon the request on 07/03/1977, has executed an undertaking and bonded the land on condition that he may be provided with a shop license with a business plot and any other facilities. Handing over the land to the government of Arunachal Pradesh, the said land is being used as a assistant engineer's office and public works departments of government of Arunachal Pradesh. The plaintiff has submitted bills regarding the numbers of spending valuable horticulture and agricultural plants in his land to the circle officer for granting a compensation. The said bill was misplaced in the office of Tribune. Even after submission of the bills, no compensation has been granted to the plaintiff, and the terms and conditions mentioned in undertaking executed on 7 March 1973 is not a doubt. Every year, the plaintiff has requested the circle officer order, but no action has been taken so far. The plaintiff on 2015 has issued legal notice to the Secretary Public Works, Itanagar, Deputy Commissioner, etc. for complaints of undertaking dated 07/03/1977 and claiming for the compensation for the land. Thereafter, on 24/12/2016, the plaintiff has issued one reminder regarding the legal notice. It is pleaded by the plaintiff that Commissioner Alo, without following the procedure prescribed for acquisition of land under Land Acquisition Act 1894, has taken the land of the plaintiff and undertaking dated 7 March 1977 is not carried on. In the present case, the defendant has not filed any statement, hence no issue can be framed for determination of the case. However, in the present case, the following points for determination of framed by the court for efficiently deciding the claims of the plaintiff. Points for determination. Number A, whether there is any cause of action for the suit and whether the suit is filed within limitation. Number B, whether the plaintiff is entitled to recover the possession of land measuring 2,155 square meters from the possession of the defendants. Number C, whether the plaintiff is entered in to get any compensation from the defendant the land and horticulture and agriculture tree of land. Number 8, now let us decide the point for determination in view of the beings, plans and exhibited documents submitted by the plaintiff in support of its claim. Let us decide the one for determination one after another. Number 9, Your Lordship, point for determination, whether there is any cause of action for the suit and whether the suit is filed within limitation. 10, the case of plaintiff is that the plaintiff had a plot of land at Tribune. In the year 1977, in March, plaintiff had donated his plot of land to the government of Arunachal Pradesh for construction of government infrastructure. Accordingly, the government of Arunachal Pradesh has constructed the office of the assistant engineer of the plot of land. The plaintiff had executed an undertaking on 7 March 1977 while donating his land. The plaintiff has exhibited the said undertaking is exhibit number 2. I have gone through with the same. It reads as, I, Sri Yorkov Gade, on the many acres of costly land do hereby agree to donate the lands wood horticulture garden. There are lots of spelling mistake, Your Lordship. Wood horticultural garden to the government at free of course, provided I am given the following facilities. Number 1, a shop license with plot of land for shopping purposes may be immediately be sanctioned. Number 2, in future, any wanted facilities be given to me, for I have donated many acres of costly purchased land which are horticultural garden. In the said undertaking by the plaintiff, in presence of 3 witnesses, I have found that there is no signature of government official, neither any undertaking was executed by the government of Arunachal Pradesh for providing facilities to the plaintiff. On the other hand, the plaintiff has donated his land to the government free of course, as it reflects from the undertaking executed by him. Hence, the plaintiff has no right for claiming that the land from the government of Arunachal Pradesh or any other department, including the Public Works Department. Therefore, from the pleadings of the plaintiff and the documents exhibited by the witness, it is transparent that there is no cause of filing the present suit. On the other hand, the land was donated in the year 1977 and the present suit is filed only in the year 2016, which is after 40 years of land donated by the plaintiff. Since the donation of the land, the same is under the possession of government of Arunachal Pradesh, the cause of action, even though it would have arose, it was in the year 1977. The law of limitation provides a specific period of limitation for the right of filing a suit. The present suit is a suit which is filed after 40 years of incident. The same is beyond the period of limitation. The suit is barred by the law of limitation. The plaintiff has given one legal notice and one reminder to the defendants claiming the reliefs. The legal notice was issued by the plaintiff on 1st October 2015 and reminder on 23rd October 2016. As such, both of the legal notice and reminder are issued by the plaintiff after the period of limitation for filing a suit is expired. It is a principle of law that issuance of any legal notice, including a notice provided under Section 80 of the Civil CPC after the expiry of the period of limitation will not give rise fresh cause of action. Therefore, it is of the considered opinion that there is no cause of action for filing of the present suit. The present suit is filed after the expiry of limitation from the alleged cause of action. Hence, the suit is barred by limitation. The present decision, the present one for determination is decided in negative. It is decided that there is no cause of action for filing of the present suit and the suit is barred by limitation. Point 12, point for determination, whether the plaintiff is entitled to recover the position of land measuring 2,155 square meter from the position of the dependent. In the present suit, the plaintiff has claimed for recovery of the land measuring such and such from the position of the dependent, specifically the Assistant Engineer Public Works Department. In the present case, the plaintiff has donated scheduled plot of land to the dependent for construction of government infrastructure. Accordingly, the government of Arunachal Pradesh has constructed the office of the Assistant Engineer Public Works Department and the same is functioning accordingly. Now, plaintiff after lapse of 40 years does not have any right for claiming the recovery of the part of the land which was donated by the plaintiff. I have seen the exhibit 1, which is a trace map of the alleged suit land. The exhibit number was not a certified copy obtained from the Land and Revenue Department. Neither the same is shown to have been prepared by the Land and Revenue Department. Accordingly, the same is not proper document to be relied in the suit. The Transfer of Property Act provides that once the land to any party, the same is full and final and recovery of the same is not provided under the law. On the other hand, after the land is donated by the plaintiff, the dependent is under the position of the suit land and the plaintiff has not claimed to be in position of the suit land after 1977. Hence, this court is of the opinion that the plaintiff is not entitled to recover the position or claim back any portion of the land property from the dependents. The present one for determination is decided in negative. It is decided that plaintiff is not entitled to recover of the position measuring such and such from the position of the dependent. Point number 15 for determination, whether the plaintiff is entitled to get any compensation from the dependents regarding the land and horticulture and agricultural trees or the land. The present suit, plaintiff has claimed that plaintiff is entitled to get adequate compensation for standing trees of the scheduled land, including the horticulture and agriculture trees. It is the case of the plaintiff that while donating the land, there were lots of trees planted by the plaintiff. The plaintiff has claimed compensation for the horticulture and agricultural trees stood over the land. The bill submitted by plaintiff is misplaced by the office of the circle official till that not a single penny has been given to the plaintiff as compensation. On the other hand, it is also claimed that dependent has not given any facilities, including the trading license, which was one of the conditions at the time of donating the land to the dependents. The plaintiff has further pleaded the Deputy Commissioner of West Siang District has taken the land of plaintiff without following any procedure as provided under the Land Acquisition Act 1894. In the present case, the plaintiff has admitted that he has both of the land to the government of Arunachal, donated the land to the government of Arunachal free of cost. Once the land is donated for your cost, the plaintiff does not have any right to claim any compensation under the Land Acquisition Act. Regarding the facilities will be provided by the government of Arunachal Pradesh and the trade license with suitable plot of land in the market area. I have not seen any undertaking given by the Deputy Commissioner or any other government official. The undertaking dated 7th March 1977 was signed by the plaintiff only in presence of witness. There was no undertaking on behalf of government of Arunachal Pradesh, including the Deputy Commissioner of Public Works Department. Even though there would have been any undertaking for specific performance of the same, the suit have been filed within 3 within 3 years of the undertaking as provided under the law. The present suit is filed after the lapse of 40 years. In view of above facts and circumstances of the case, I am of the considered opinion that plaintiff is not entitled to claim any compensation from the dependent. Decision, the present suit for determination is decided in negative. It is hold that plaintiff is not entitled to get any compensation from the dependent. The learned counsel plaintiff has submitted and relied 3 decisions of the Honorable High Court. I have perused the same, found this is said decision relating to the plaintiff. I nowhere relate to the fact and circumstances of the present case. And the law point involved in the present suit, the citation relating to the law of adverse position. But in the present case, no such question of adverse position is involved. Hence, I am of the considered opinion that decisions are not required to be discussed in the present judgment. Order, in view of discussion made above and decision reached in foregoing points for determination, the present suit is dismissed. The bench accordingly.
Okay, so you file appeal.
Yes, Your Lordship.
Where is?
Page number 52. Appeal is in page number 55, annexure 9. May I read, Your Lordship? Judgment. This appeal is page 55, annexure 9. This appeal is directed against judgment and decree dated 18/04/2017, passed by the Learned Judge Senior Division, Western District, Alo, entitled suit number 20/11, which was dismissed on maintainability and other grounds. On receiving the notice of the appeal, 2 officers, namely Sri Horki Dium, EAC, and Sri Modak Riba, AEPWD, appeared in the court to represent the respondent. But during the hearing of the appeal, none appeared for the respondent. I have gone through the memorandum of appeal containing grounds on which the appropriate judgment and decree has been exiled. I have also gone through the impugned judgment and order and decree, as well as the pleadings of the parties, evidence recorded and document exhibited entitled suit number 20/2016. The case of the plaintiff appellant herein as disclosed in his plan in substance are mentioned in para number 2, 4, and 5, which are quoted herein below for ready reference. 2, the plaintiff stated he was having an ancestral property at Tirbin area, now circle of Western District, having land measuring 370 square meters at the heart of Tirbin Circle, now donated to the government of Arunachal Pradesh, and this land is used by the Assistant Engineer, Public Works Department. The said land has been description as herein under North Dapo Market, BRTF Road, South Extra Assistant Commissioner Office, East Shiru Market, West ancestral land of plaintiff of Yorkop Gade, land 3780 square meter. Number 4, paragraph number 4, that the plaintiff states in the year 1977, government of Arunachal Pradesh, particularly Deputy Commissioner Western District, had asked and requested to the plaintiff to donate this said land for the establishment of government infrastructure. That plaintiff states that he agreed upon their request, and government authority has instructed the plaintiff to take undertaking before the appropriate authority with the presence of valid witness, Sri Karsen Riba, Tommy Riba, interpreter, and Sri Nyapek Lombu, political interpreter. This said undertaking was executed on 07/03/1970 with terms and condition to a shop license with a business plot, be any facilities, that is contract work. In substance, the case of plaintiff is that he owns ancestral measuring such and such situated at Tirbin town in the year 1977. The dependent number 2 Deputy Commissioner Western District, Alo, requested the plaintiff to donate the appropriate land for establishment of government infrastructure. The plaintiff accepting the request gave an undertaking on such and such, donating his ancestral land free of cost to the man for sake convenience. The undertaking is quoted below. I, Sri Yorkop Gade, owner of such and such, Your Lordship. I, Sri Yorkop Gade, owner of many acres of costly land, do hereby agree to donate the lands with horticulture garden to the government at free of cost, provided and given the following facilities: a shop license with a plot of land for shopping purpose may be immediately be sanctioned. In future, any wanted facilities be given to me, for I have donated many acres of costly purchased lands with a horticulture garden. At present, the office of the Assistant Engineer PWD government of Arunachal is functional over the land with all this and other infrastructure. On 01/010/2015, after almost 38 years after donating the land on such and such, the petitioner issued legal notice to dependent number 1, Secretary PWD, Government of Arunachal Pradesh, Itanagar, to compensate 2,155 square meters of used land and return 1,165 square meters of unused land. Another legal notice dated 23/12/16 was served to the dependent number 1 on the same ground. When the plaintiff received no response to his legal notices, he instituted the title suit number such and such, and dismissal of which has given rise to the present appeal. The present respondent were arrayed as dependent in the title suit number such and such. The dependent, despite the notice of the title suit number 2011, did not file written statement or contested the case. The landed civil judge, Senior Division Alo, by order dated 13/07/2006, initiated ex parte proceeding in view of non-representation of any of the dependents. The plaintiff adduced 3 witnesses and exhibited 5 documents, in which P exhibit 2 is the undertaking dated 1977. After hearing the learned counsel for the plaintiff, the learned CGM passed the impugned judgment on 18/04/2017. Since the dependent filed their written statement and the proceeding was ex parte, while passing the judgment, the learned court below framed following points for determination. Number 1, whether there is any cause of action pursued and whether the suit is filed within the limitation, whether the plaintiff is entitled to recover the position of land measuring such and such from the position of the dependent, whether the plaintiff is entitled to get any compensation from the dependents for the land and horticulture, agriculture, trees of the land. The landed court below held all the above 3 points of determination in negative and dismissed the suit. Being aggrieved, the appellant prepared this appeal mainly on the grounds that court below committed error in dismissing suit on the ground of limitation, as according to the appellant, the cause of action arose on 01/010/2015, 24/12/2016 on sending of legal notice. The grounds urged by the appellants are very conceived. Points for determination: whether the impugned judgment and decree passed by the learned trial court suffer from any illegality and warrants interference in this appeal. Discussion, decision, and reason thereof. Now let me discuss the following. Why is the point of the determination and the reason given by the learned court below? Point number 1, in regard to the point of determination number 1, the learned court below held that suit was barred by limitation on the ground that appellant plaintiff expressly donated the suit land to the government for establishment of government offices by giving an undertaking dated 07/1977, exhibit number 2. After passing 38 years, plaintiff approached the dependent for the first time for compensation and return of the first time compensation and return of suit land. It is pleaded case of the appellant plaintiff that he donated the land to the government under few terms and conditions, being agreed by the non-fulfillment of the condition stipulated in the undertaking dated such and such. The plaintiff sent legal notice to dependent for the first time on 2015 and the second time on 2016. In view of the admission of the appellant, the suit was ex parte barred by limitation. Thus, the learned court below has not committed any irregularity or illegality in any manner in understanding the correct facts of the case projected by the plaintiff. The learned court below rightly came to the conclusion that suit in question was hopelessly barred by the limitation. Hence, the point of determination number 1 decided by the learned court below warrants no interference, and the same is upheld. Point number 2, in regard to the point of determination number 2, the learned court below held that plaintiff is not entitled to recovery of suit land measuring 2,155 square meter on the ground that for the last 40 years the dependents are in possession of the suit land and have constructed permanent government buildings. It is admitted case of the appellant plaintiff that after donating the suit, dependents have constructed offices over it. The appellant plaintiff has not adduced any evidence to show that he raised any objection to the construction of the government offices over the suit land, and now after lapse of almost 40 years, the appellant is stopped from removing or recovering the suit land under principle law governing estoppel, acquiescence, and waiver. According to the reason, findings, and decision of the learned court below with regard to the point of determination number 2 does not suffer from any legal and factual infirmity warranting interference. Consequently, the decisions on point number 2 is upheld. Point number 3, in regards to point number 3, the learned court below held that plaintiff is not entitled to receive any monetary compensation for land and horticultural trees on the ground that land in question was donated free of course. In undertaken such and such, the plaintiff explicitly stated that he is donating the land to the government free of course, provided he is given a shop license along with land for shopping purpose and also some facilities in lieu donating with the horticulture garden. It is true that plaintiff donated his ancestral land in expectation of some benefits, but not in the form of monetary compensation. The plaintiff has belatedly claimed monetary compensation for his suit land by virtue of deciding points of determination number 1, the present 1 and 2. The present point of determination automatically gets negated on the ground that plaintiff was inordinately sleeping over his right. Therefore, the learned court below was correct in arriving at the findings that the plaintiff monetary compensation. Accordingly, the decision on point number 3 is also upheld. In view of above findings and decision, the grounds urged by the appellant and also on upholding the decision of the court below, the present appeal is liable to be dismissed and the same is dismissed. The impugned judgment repassed by trial court is just and proper and needs no interference. The point of is this was the appeal.
Yes. So I think we have to keep it as a part hard.
Yes.
We are running sort of. Okay. Yeah. So hard, Mr.
Raksap.
R.
Raksap.
Raksap, counsel for the appellant. Also hard, Mr. Rera. Counsel for the, how many respondents?
5.
5, no? For all the respondents. Fair. Due to paucity of time, the hearing could not be complete. Please this matter again when?
Tomorrow there is the bill, let it be on 17 or 18 years.
We'll fix it again on 17 or what?
Yes, that would be okay.
Hmm?
As per convenience, 17 will be okay.
Okay, 17.
Deeply obliged.
Just a minute. Just a minute.
Item number 27, unlisted motion matter.
Yeah.
So this affects customer code. Also, the big fact is, I have filed this CRP. The ground of lack of jurisdiction, abuse of power, violation of Lordship, the nature of the case is purely criminal in nature. However, they have filed a complaint before the Arunachal Pradesh Civil Court.
Where is the, have you annexed the complaint?
Yes.
Where is the complaint?
Complaint. This has been filed by one's margin line, blazing. May I read the
26. 26.
27. Annexure 6.
Okay.
May
Yeah.
2C presiding customary judge of our apex customary court of anarchists. Apart Dobam Bandadua, UPS, subject complaint Kambu, son of Kili Kambu, for committing forceful sex, illicit relationship, extramarital affairs with the wife of Vito Martina. The complaint has been filed by husband of his wife. Respected sir, as cited above subject, Sri Likian Kambu, son of Kili Kambu, has committed forceful sex with my wife, Srimati daughter Ribardo. In several occasions, as per the friend of my wife has told me that my wife was crying while talking to someone on telephonic conversation in many occasions regarding the extramarital affairs. Later on, I had inquired about and asked my wife. Later on, my wife, Srimati, daughter Ribardo, has replied by stating that they can compose forcefully committed sex with her without her consent and said it's been happened twice. Therefore, the legal number has keep on blackmailing my wife that with make this public. If my wife doesn't allow me to continue the sexual relationship, and even later on, my wife confessed to me that the legal number has promised her with confidence keep her as lawful wife by customary settlement with me as per the private custody law, but the legal number has continuously committed forceful sex for months by visiting my respondent, Danagat, the also in my website. Since I am residing at Avatani Colony, Danagat, Danagat, Mr. Kapumpar, Arunachal Pradesh, and the alleged accused Legion Kambu resides at Nivan Colony, Nahalagan, Place Nahalagan, Arunachal Pradesh, and even the offense is nature as per the private customary law practices of Arunachal Pradesh, which may escalate law and order problems. Since all the parties are residing in Danagat and Nahalagan, therefore your ethics customary court take cognizance of the case and solve the case as per the private customary law and practices of Arunachal Pradesh by calling the family members of the Sri Lankan company so that the peace and harmony will be maintained in our country. Therefore, I request your good office issue made order resolve the case. This is for your kind consideration and immediate action is yours sincerely. And pursuant to this, page number 22. This is first mail order, however, under the title show cause notice. This notice has been served upon me. I am the natural father of the Liken Kambu, against whom the complaint has been filed.
Liken, what is his age?
He is 17 years. The next is
The accused is 17 years old.
this is just an accuse as per the allegation. They have not filed any police complaint anywhere. After receiving this all complaint, I have lodged complaint before the CWC for recommendation of for fair and transparent dispute. Because even my son is confused and he's innocent. What he is stated is they were the PUBG online game friend, not more than that. Before this, they made the complaint before the Gaonpura Key Sector Itanagar Capital Complex. Even I received the notice from there while I was pursuing to get obtain copy of complaint from Itanagar Gaonpura. Subsequently, to my utter shock, again I received another notice from Arunachal Pradesh. This is our Apex Customary Court of Arunachal Pradesh.
It was, the mail order was fixed on 12/8.
The first mail order, the first mail order.
What happened there? What happened there?
No, they have not conducted this. I have gone there, I submitted application, page number 20 is the application that I submitted before them for a copy of the complaint. However, they have not continued. Thereafter, I have again received the page number 22. Next, first mail order from Arunachal Customary Court of Apex Customary Court of Arunachal. Your Honor, in the show cause notice, first mail order itself, is categorically mentioned that according to AP Civil Courts Act, this notice is being issued. However, going by the allegation, is purely serious criminal offense. But there is no mention of when was the offense occurred. 4 months, my minor's son was sexually assaulting his wife. But my minor son is in Mio, studying in class 12.
What is this letter about 19/8/2025? Chairperson Child Welfare Committee. What is this?
This is the formal complaint that I have lodged for the Child Welfare Committee for Mumbai. After receiving these notices, because the notices of serious criminal offense. Even I was innocent, I was unaware of all these offenses that my son, if he has committed, had committed. However, my son denied that whatever the allegation they have alleged. Only his statement is that they were the PUBG friend, online PUBG. Thereafter, and in the online PUBG friend circle, his wife, he introduced herself as single. After coming to know that he is a married woman, thereafter here my son avoided her, then this whole complaint started. It was completely, we were completely unaware of all these complaints. Page number 19.8 is the, since my son is a minor, therefore we have approached CWC for recommendation to the investigating authority for investigation. After preliminary investigation by the CWC, they have recommended to Chairperson Arunachal Pradesh State Commission for Protection of Child Rights, is in page number 29. They have recommended before this, before Arunachal Pradesh State Commission for Protection of Child Rights.
Too long complaint. Very long complaint. This is complaint or what? This is information.
Information is annexing all the documents that we have received. The basic ground for approaching this honorable court is one, the civil court doesn't have the jurisdiction to entertain any which are criminally related. Two, the case of sexual assault. The forceful sexual assault is alleged in the complaint. One. Second is lordship. The forum is Arunachal Pradesh Apex. The Apex Customary Court of Arunachal Pradesh. If this be the position, there will be no territorial jurisdiction. This forum, if allowed, shall be empowered to try any case, irrespective of jurisdiction.
The notice was issued under. Proposed notice was issued under.
The section 3 of A.
Where do we find?
This,
Page.
no, they have not mentioned the section, but that it is page number 22. Second para. Therefore. Therefore, you are directed to attend customary hearing fixed on 17 days before the instant Apex Customary Court, which is DB of this upper Dover Customs hearing, to place your justification and to adduce the evidence by bringing all the witnesses and evidence. Otherwise, the undersigned.
No, when the next date is fixed? 17th of?
Yeah.
Where is that?
It is in subsequent notice, because this is the first notice. In the first notice, there was no complaint, the complaint was not annexed. Then I have written to them citing it, I have, the complaint filed by when it is not annexed, therefore the complaint will be. And I have categorically stated that I will not be able to attend the man because of the jurisdiction issue. Then they have.
Or Mr. R. Koyo, Land Council for the petitioner. Para. By filing this application under Article 227 of the Constitution of India, the petitioner challenged the mail order dated. It's order or notice?
They have written order.
Where do we find? It's a so-called notice only.
It's about so-called notice, second mail order. First is first.
Second mail order, so-called notice. It's so-called notice only. Second mail order stroke so-called notice dated 17/8/2025. Issued by the head Gambura presiding customary judge of the Apex Customary Court of Arunachal Pradesh, come president of AAPGB and GBWA. By which the head GB, presiding customary judge. Where is the direction? Directed the son of the petitioner, who is minor, to attend customary Nile, NYILEY, fixed on 17/9/2025. Along with the witnesses and evidences or else the matter would be, or else order would be passed ex parte against the applicant's son. It is submitted that the respondent number, the respondent filed complaint dated 11/8/2025 before the head Gambura, Itanagar Capital Region. No, where is the complaint? Or before the, okay. Head GB, huh? Presiding customer, okay. Head GB. Presiding customary judge of Apex Customary Court of Arunachal Pradesh. Upper Dobam, Bandardeva Circle. For committing forceful sex within bracket illicit relationship stroke extramarital affairs bracket close with the wife of with his wife by the son of the petitioner. The land council, the land council for the petitioner submits that from the mere perusal of the complaint. Expressly, it reveals that the allegation against the son of the petitioner is criminal in nature. Stop. And the GB stroke customary court under the Arunachal Pradesh Civil Code Act doesn't have power and jurisdiction to try the trial such case, to trial penal case. Now, GB, head GB stroke presiding customary judge of Apex Customary Court of Arunachal Pradesh. The that instead of G, only GB, instead of only GB, this presiding customary judge under Arunachal Civil Court Act doesn't have a power and jurisdiction to try such cases. Stop. Issue notice. Call for the record. The petitioner shall take steps for forging of service of notice upon the respondent by a registered post with AD as well as by usual process within a week from today. Start. List this matter after 3 weeks. After 4 weeks, okay? Para. Having regards to the contention made, it is provided that the where is the interim notice? Only the last notice will be counted. Last notice, 20, last notice. The notice. Sorry, the second mail order of so-called notice dated 17/8/2025 issued by the head GB presiding issued by within bracket HGV presiding customary judge of the apex court customary Arunachal Pradesh presiding president of AAPGB and GBWA shall remain state till the next returnable date. Okay.
Item number 26.
After the question. On the prayer of both the Land Council for the party, let this matter be listed after vacation.
On 23rd of
You want date fixed? Yes. Okay, on 23rd October.
October.
Okay. List it accordingly. Okay. This is 26.
Last.
Oh, last.